item 22, the last matter on board, we have informed the other side if the matter can be upgraded and taken. Course of the day, there is an order passed by the Honorable for expeditious hearing, and Lordship last day order of 26 February in item 22 has also said that it will endeavor made to dispose of the for the appellant. If Lordship indicates any time at 12 noon or so, we can inform the other side. Item 22. This was called on last day of it, which was 26 February. An order passed by the Honorable 5, which your Lordship had the occasion to.
We can take up after the miscellaneous matters.
Correct.
Well, two reply affidavits in this case have been also filed. Two reply affidavits that may also be called for. Palace. Great.
Please, Lordship. Item number 5. Wrongly for orders. It had to come for hearing. So maybe fixed on, I also informed the appellant. The fixed on 7th of April.
Lord, I appear for the appellant. On last occasion, when the matter was listed, it was agreed between the parties that attempt would be made to dispose of the matter on 12th. Although it is on orders, there is no harm in taking up the matter for final disposal. All issue involved, Lord.
I have some difficulties. So the date, my lord, 7th of April will finish it. Hearing list.
Why not next week?
Huh?
Why not next week?
I have some difficulty. A lot of cases is. I also informed yesterday night.
Pending since 2000.
Okay, I agree on a date.
But the 7th of April,
My learned friend is so anxious to do it.
I've taken the consent of this, my.
Matter is item.
Item number 26. So, my lord, some accommodation. I'll take the hearing, appeal at 2 p.m. my lord.
We don't know.
My lord, that is just inform this honorable. Much of this.
Permission, I'd like to mention item number 8. My name has been, yes, my lord, I have already given a note. Subsequent counsel has already filed the wakalatnama. My lord, my name has been request, but it seems that the name is still showing.
M8.
8, my lord, for the petitioner. Subsequently, I think counsel has already filed the wakalat. Yes.
No, I also adjourned this.
I'm only saying that my name may be deleted, my lord, that's all.
Was this
Petitioner, for the petitioner, R.B. Fuka.
item 8?
8, my lord. Pradeep Kumar Saraudi.
Engaged counsel has also. His name?
I'm sorry, my lord.
Newly engaged counsel, his name.
I think Mr. Bora has filed in wakalatnama, madam. What I could find out yesterday. Yes, his name is also reflecting.
They may appear.
Yes, absolutely, ma'am. Extremely great.
The consent of other side, Lordship, I beg to mention item number 7, Lordship. I pray for some little accommodation for today, Lordship. Let the matter come up, Lordship. 17th. If I've taken consent of the appellant side also.
For the appellant.
The appellant lays the matter.
Lordship. To mention for
8.
I beg to mention item number. Handed over the brief. Any lordship.
He has handed over the brief to the company. How is the registry supposed to know it? There is a procedure in the Guwahati High Court rules. Followed that. Long as you don't inform the registry, it's remain like that. Go as per Guwahati High Court rules. Yes, next.
In item number 13, I am Lordship, may I please, your Lordship? I will mention item number 4. Appellant for the wait.
Item 14. 1-4.
13 and 14 are similar matter. I was to file addition.
So you are for the respondent.
Yes, Lordship. Respondent in item number 10, Lordship.
Appearing for respondent number.
M.
Arguing counsel is in bereavement. A. Bhattacharya.
A. Bhattacharya Learned Counsel.
To item number 15 and 16, my lord. I have taken consent, learned friend, my lord. But I'm the appellant in item number 16, my lord. There's some difficulties. It may fix up.
I'll write on the prayer of
I am for the respondent in item number 15 and yes, Lordship.
This was earlier, my lord, on last occasion, it was listed. Line has not considered for any. My lord, settle at hearing only, my lord. So file a cross objection.
Learned Counsel for the appellant.
I'm sorry, my lord, I'm for the response. Amen.
Carrying on. So,
In this case, Lordship, I have not taken step. Lordship has earlier occasion asked to produce a authority that Lordship can Supreme Court judgment. Lordship, as an advocate, I am taking that. Lordship, my fault. Lordship, steps has not been taken. Be allowed to take first steps on. Not on merit, Lordship.
You want to submit?
Lordship had asked to produce the authority that advocate for the advocate called petitioner not suffer.
Has happened here. We don't have everything in our mind what happened in the last occasion.
Lordship, what happened, Lordship? Page number, Lordship, 41, Lordship. Lordship, page number, before 41, Lordship, page number 39. Kindly see. In this case, Lordship, yes, in this case, Lordship, I have filed a title suit before the landed court below, and there were 3 defendants. I have taken steps against states, Lordship, but however, he has been appeared and filed WS. And taking several steps, Lordship, court has one day 26/2/2020 asked me to face steps against respondent number 1 and 2. I have taken steps, Lordship. And what happened, Lordship? Page number 39, Lordship. Another petition, Lordship, it has been mentioned that I have not taken steps like as per the order and the suit against the defendant number so has dismissed. And Lordship, after this, Lordship, I have come to the court and no, I have taken the steps and Lordship, and already defendant number 1 has already appeared, Lordship. And then court, page number 41, Lordship, then Lordship. Page number 41, Lordship, that has been passed that you have taken the steps on the defendant number 1, he has appeared. But against the defendant number 2, you have taken step after the court order. So against this last order, so after the dismissal of the suit against, so against the defendant number 2, suit has been dismissed. Yes, Lordship. Lordship, therefore, Lordship, I pray to take first steps, Lordship, against defendant number 2, because suit is against the defendants, Lordship. Earlier occasion, I have 7 steps, Lordship. Page number 42, last order, Lordship. Therefore, Lordship had earlier occasion asked me that the producer authority that I can say you that for taking the burden, Lordship. I am taking the burden, Lordship, as an advocate. I have forgotten, Lordship, not on merit, Lordship. Due to my oversight, Lordship. taken steps from 2023, Lordship. One step. People hear the matter and wait.
Lordship, my senior is up. Code number 18.
Where is it listed today? Where is it for admission?
Lord, this is for admission. Now, the fact of the case is very short, my lord. What happened, my lord, deceased is Atul Chandra Barman. He met with an accident way back on 13/4/2000. And my lord, the wife and two sons of the deceased filed. And total compensation was given 50 lakhs and odd. Now, your lordship will find, even the wife herself, she admitted that she has been getting the salary every month, even after the death of the deceased. Now, I will take your lordships to page 33. The notification
Right,
dated.
then let him come if it is
My lord, yes.
got to be heard.
Published.
In this case there was call for my,
Yes, your lordship.
both the cases, my lord. It's a counter case is there, my lord.
23-25 lordship, we have received the case diary, and 24-25 lordship, Polasbari PS. That case is charge sheeted, lordship.
What new ground is there?
My lord, this application is under section 482, my, and the petitioners are from the same family, my lord. The petitioner's family had a plot of land, my lord, in their village, which is cultivated by them. On 12/11/2025, my lord, in the morning, they received an information of family along with others. They cut down the paddy. So immediately they reached the paddy field, my lord, and requested to not to do so, my lord. But at this, my lord, the information families and others, my lord, already they are equipped with some sharp weapons, my lord, and attack them. As a result of which a marpit took place, my lord, in which, my lord, the petitioner were to lost his fingers. And petitioner's brother, one brother and his mother, they got a severe head injury. And others were also, my lord, my lord, and they were admitted in the, sorry, my lord, they were treated in the, my lord, Gauhati Medical College Hospital. And in this fight, my lord, the informants, one of them died, my lord. Thereafter, affairs were lost by both the family.
That incident where one person was died.
Died,
by
my lord.
informant side. Then PM report is pending for receipt of official report. The injury part was there. It shop one of size 11 centimeter, 3 centimeter, cavity deep is present. No, multiple injuries are there. This is where implicated the petitioner.
Who were the persons involved in this attack, my lord?
The earlier order.
Rejected, my lord.
They're not rejected.
Not
Is it here?
this
Has
case,
it
my
been
lord. It
listed
is
here?
filed on, my lord, 29/1/2006, my lord, and waited for, my lord, the CD to come, my lord.
Why has it come up here? Top of the file, same rejected accused.
No, my lord. Rejected. These petitioners are, they are pressed, my lord. This case is pressed, my lord.
This case may be faced lordship, but other some persons were arrested in this case. That may be rejected by your lordship, maybe.
Other persons.
The person, so some persons were arrested, na, in this case?
Persons were arrested, my
person
lord.
may be a-
One of which, my lord, one is granted bail by the, my lord, learned session judge, Amin Gao.
What has this court to do with that?
Then lordship.
Regarding these persons, my lord, these petitioners, they didn't approach my lord earlier, my lord. Appeal case is also going on, my lord, title suit. Filed by the informant side.
Only listed. I'm not the appropriate bench. That the matter has been
Lordship.
Obliged, my lord.
But I will take your lordship to page 33, my lord. This is the notification, my lord, the holding the field, and this case is covered by the judgment of coordinate bench of this honorable court. The lordship kindly see that it is on 14th September 2017. The scheme for compassionate family pension in lieu of compassionate appointment, in short called compassionate family pension scheme. Your lordship straightway come to page 34, 5.3, last para. Where the employee dies before superannuation, the family pension equal to 100% of the last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee, that is the date on which the employee would have superannuated had he been alive. This would compensate the loss of family income to a large extent and fulfill the requirement of compassionate conditions arising out of death of the serving employee. Now, the 5.4, the last pay drawn for this purpose is the last basic pay plus grade pay over and above the compassionate applicable DNS. That means they will be getting the entirety of the thing. Then, my lord, at page 36, is 5.11. The scheme is applicable to those employees who died or die in harness on or after 1/4/2007. So far, this notification is concerned, it covers this case. And now, my lord, straightway I'll take your lordship to a decision on this issue passed by the coordinate bench. I'll read from the paragraph 2, my lord. This appeal arises out of the judgment and award dated so and so. passed with the learned member, Motor Accident Claims Tribunal, Darang, Mangaldevi, whereby the tribunal adjudged that an amount of rupees so and so along with interest per annum from the date of filing of the claim petition, that is, realization would be the just fair compensation. Case of the appellant in brief is that the learned tribunal below failed to take into consideration the notification dated so and so issued. The lordship come to para 4. For deciding the said aspect of the matter, it would be relevant to take note of the facts of the instant case. The parties herein are referred to in the same status as they stood tribunal below. 23/12/2018 at around 4:20 p.m. on Govinda Kalita, since deceased, was returning from Mangalde towards his dwell after by motorcycle being registration of so and so. When he reached Punia, the offending vehicle bearing number so and so knocked down the late Govinda Kalita, as a result of which sustained grievous injury. Late Govinda Kalita was thereafter taken to Mangalore. Come to his injuries on the way to the hospital. A postmortem of the deceased was done at Mangalde Civil. Connection with the said accident, Mangalde claimant, who is the wife of late Govinda Kalita, member Motor Accident Claims, was registered and numbered as so and so. The said claim petition, it was mentioned that Govinda supervisor Kanungo in the office of the circle of and drinks a monthly salary of rupees 41,800 and was the only earning member of the family, wife and 3. Basis thereof, a compensation of 80 lakhs was claimed. The opposite party number 1, that is the owner of the vehicle, being registration number statement, stating inter alia that the offending vehicle was valid from so and so, with the covering all risks and liabilities arising out. It was also submitted that the driver was possessing a valid driving license number. The appellant was the opposite party number 2. All filed its written statement. The claim proceeding was not. The claim is bad for non-gender of. The opposite party number 2 had put the claimant to the strictest regard to the alleged accident. It was also denied by the opposite party number 2 that at the relevant point of time, the driver had been flying the vehicle by complying the traffic rules and provisions. Now, para 8. On the basis of the pleadings, the tribunal will frame as many as 3. Number 1, whether the deceased died out of the alleged accident due to the offending vehicle number. Whether the offending vehicle was duly covered. During the course of the trial, the claimant examined herself, one so and so, proved some of the documents. The opposite party duly cross-examined. However, the opposite party did not adduce any evidence. Tribunal will write the judgment 22 decided the issue number 1 in favor of the claimant. Now, your lordship may skip this para. Lordship can come to paragraph 12. The so and so learned counsel for the appellant has submitted 168 of the Act 1988 empowers the claims tribunal to determine the amount of compensation which appears to be just. Learned counsel for the appellant further submitted that have been defined Act 1980, but by interpretative process, it has been understood to compensate the claimant for the possible loss suffered or likely to be suffered, sudden and untimely death of their family member. Learned counsel further submitted that the measure of compensation. Secondly, no double benefit. Your lordship kindly give stress on this. Secondly, no double benefit should be passed on to the claimant in the matter of award of compensation. Referring to a notification issued Finance Department dated so and so, The learned counsel for the appellant submitted that the family of the deceased in terms with the said notice would be entitled to 100% of the last bedroom, which revised periodically, pension revised. Under such circumstances, the learned counsel for the appellant submitted that as the notification is applicable in respect died, die in harness on or after 1/4/2000, the claimant has already got the benefit under the said scheme. Determining compensation without taking into consideration to be just compensation in section 168, and it would amount to enduring upon the claimant double benefit which permissible. In that regard, the learned counsel for the appellant has relied on the judgment of the Supreme. On the other hand, Mr. Deka, the learned counsel for the respondent, that in terms with the said notification, claimants are getting is a compassionate family pension. At this stage, it may be relevant herein to mention that this matter hearing on so and so, and the learned counsel appearing on behalf of the claimant was requested to obtain instruction as to whether the claimants are receiving any benefit under notice so and so. Government of Assam compassionate family pension. Learned counsel for the claimants with all fairness submitted to the Your Lordship may come to paragraph 16. From a reading of section 168 of the Act, it makes the first principle subsection 1 of the said provision makes it clear the amount of compensation must be just. The Supreme Court in case of Sharla Verma and so and so observed the compensation is not intended to be one largest or source of profit. It was observed that it would depend on the facts of each what amount would be the just compensation. The principle as would be discernible from the judgment of that. If the amount would be due to the dependents of the deceased, it shall not be deductible. At the same time, it must be borne in mind that the loss of income is a significant head under compensation is claimed in terms with the Act 1980. The component of quantum of loss of income, pay and wages, which otherwise would have been earned by the deceased employee, yet survived the injury cost. If the dependents of the deceased, however, were to be compensated, in that we have, that is to grant compassionate assistance of ex gratia finance, compassionate grounds, lies in harness. It would untenable that the dependents can still be permitted to claim this possible or likely loss of income suffered by them. Compensation. My Lord, Your Lordship, this is the scheme I have taken to Your Lordship, so Your Lordship where to go into that once again. I'll take Your Lordships to page 11, my Lord, paragraph 19. A perusal of Rule 5 and its sub-rules give a detailed guidelines as to how benefits are to be given die in harness. Rule 5.3 stipulates that when an employee dies before superannuation, the family pension equal to 100% of the last bedroom by the deceased employee be paid for a period up to the date deemed superannuation of. That is the date on which the employee would have superannuated had he been alive. The objective behind the said sub 5.3 is to compensate the loss of family income to a large extent and fulfill the requirement of compassionate arising out of the death of the serving employee. Sub-rule 5.4 stipulates that the last paid role for this purpose is the last basic pay, paying the payment plus grade pay, over and above the compassionate. Further to that, it has been mentioned that the family pensioner will get the applicable dearness relief and other amounts as admissible in the normal family pension. Sub-rule 5.5 stipulates that the C at 100%, the last paid loan would be revised periodically as and when normal pension. Sub-rule 5.6 relates to that on attaining the date of deemed superannuation, the CFP would be converted into normal family pension. Therefore, from a conjoint reading of the above rules and more particularly Rule 5 and its sub-rules, it would show two aspects. First is to compensate the dependents of the deceased government employee by getting a financial sense on compassionate ground for the loss of pay and other allowance for a specified period. The second aspect of the matter that the dependents of the deceased would be entitled to family pension and other allowances. The basis of the judgment of the Supreme Court in the case of Helen P. Revelo, the dependents of a deceased employee would be otherwise also entitled to family pension for a nation, and these cannot be deducted from the amount of determining the just. So far, this is all okay, my lord. Then your lordship may turn to paragraph 20, my lord, at page 14. Now, let this court take into consideration the subsequent judgment of the Supreme Court as has been referred to by the learned counsel for the respondents, that is, of Sebastian Lakra and others. Supreme Court in the said judgment had distinguished Land General Insurance the ground that the scheme in Sebastian Lakra and others from the rules which were under consideration in Land General Insurance Company. To appreciate the said aspect of the matter, it would be not required to see that. Your lordship can come to paragraph 21. However, it is noteworthy to mention that the tribunal below, while determining the compensation, failed to take into consideration the proposition of law as enunciated in the Reliance General Insurance Company on the ground that the said notification was not placed before the tribunal below, which is vital relevance. For such circumstances, this court opinion that it would be in the interest of justice that the tribunal below should recompute compensation by taking into account the notification date and the judgment of the Supreme Court referred to herein above. While taking into consideration the same, the tribunal is also directed to permit both the parties to adduce evidence if they wish so. It also made clear that the claimant would also be entitled to adduce evidence to show that the amount so granted in terms with the notification and so is not the just compensation in all the effect that claim towards loss of future escalation of income and the deceased would have earned a higher income had he survived the accident. The tribunal below, while computing the compensation, shall take consideration that the dependents of the deceased employee in terms with Rule 5 of the notification date are entitled to family pension and that must remain unaffected and cannot be allowed to be deducted, which in any way would be paid to the dependents of the deceased. Now, coming into the question of compensation on conventional heads, in terms of the
Doctor.
judgment.
Go back to this. It's clear. The claimant would also be entitled to adduce it. Not the just compensation.
Your lordship is reading which para?
One that you read. 21.
21. Well,
Down below, on the middle, it is also made clear.
oh, yes. Yes, my lord. Yes.
Also granted in terms of notification dated so and so is not the just compensation. The effect that the claim towards loss of future escalation of income, the benefit is concerned, have earned a higher income had he survived the accident. He survived the accident, he would have remained in government service.
Right, my lord. What the proposition is, supposing, my lord, he survived, in that case, there would have been a scope of promotion and all that. In those circumstances, my lord, the salary will hike. So therefore, these are the things is required to be gone into by the tribunal. But what happened before the tribunal, this notification was never placed. So the learned tribunal was not knowing all that. So therefore in
In
this,
terms of the present notification, suppose he is an LDA
yes,
or whatever,
right.
the remainder of his service period, what he would have had earned last as an LDA, that would be what would be given to the family,
That is
not
the-
taking into account his future promotions.
Right, right. Now, those are the things, my lord, eventually it will determine whether he will get promotion or not, or whether he might be dismissed from the service also. Those are the things, my lord, have to be gone into by the tribunal, but that scope was not given to him. And here what happened, the proposition of law is, once you have given a benefit, you cannot that benefit twice. My lord, even the appeals court recently, my lord, that the decision in February 24 to 2026. This is a civil appeal number 2507 of 26, my lord. The lordship has decided the same matter once again, that you cannot get benefit twice. So therefore, what happened here, supposing, my lord, she has accepted that even after the death of my husband, I am getting monthly salary. Now, so for dependency laws is concern is not there at all. The only thing, my lord, certain conventional heads like, my lord, what is it called? Loss of state and the
Consortium,
consortium,
etc.
those they are entitled. So even, my lord, this honorable court ultimately what Justice Borua has said, I'll just take your lordship to that. Lordship, I'll take your lordship to paragraph 24, my lord. Considering the above, that the deceased is survived by the claimant who is the wife and 3 children, each of such dependents shall be entitled to an amount of rupees 44,000 each on account of loss of consortium, in addition to the amount of 16,500 on account of loss of state and funeral. Accordingly, on the conventional heads, they are entitled an amount of rupees 2,09,000. Then para 25. This court by the order dated so and so had admitted the instant appeal and stayed the impugned judgment and award subject to deposit of 50% of the awarded amount before the registry of this court. It has been submitted by the learned counsel appearing on behalf of the appellant that an amount of rupees 30,73,763 has been deposited in pursuance of the order dated so and so passed in so and so. The registry, on the basis of a certified copy of the instant order being produced, shall release to the claimants on an application being filed before the registry the amount of rupees 2,09,000. The remaining amount along with the statutory deposit refunded back to the appellant.
Other conventional heads, that was allowed to be withdrawn.
Exactly, my lord. So they will get only the conventional amount under such a factual scenario. So, my lord, there are
Plus redetermination by the tribunal regarding loss of future income.
yes, yes. If they want to, my lord, say that the matter may be remanded back, my lord, it can be done. They can decide it.
Yes.
My lord, that my plate of. Well, it is a settled law that there will be no loss of income up to the date of actual superannuation. But so after superannuation, pension will come and other benefit that will not be deducted. Because there is a Supreme Court decision, latest Supreme Court decision that effect also. I am relying in that lawsuit. And
My lord, with all respect to my learned friend, that apprehension is totally wrong apprehension. Because the notification has said they will get
They'll get the pension also.
everything they will get. There will be no deduction at all.
Where from do you get that will be deducted? Notification says you'll get salary full 100% till date of notional
yes, after
superannuation.
that there is no loss of income. We are not disputing on that.
Even after retirement, there is no loss of income.
After retirement, he or she will get loss of the family pension.
Yes.
So family pension
Not family
cannot be
pension.
deducted
Hmm?
from the compensation of the MSA. And lordship, I am just one latest judgment of the GC.
Let's go back to the notification. So it is termed as family pension because the employee is dead and family is getting it, but that family pension is 100%.
100%. Yes.
So full salary till retirement.
Yes, yes.
Yes. After that,
5.8, 5.9, these are very clear, my lord. as your lordship knows that even in the pension, my lord, there will be
No.
hike in DA and all that, whenever there is a hike.
Mentioned in the
yes.
notification itself.
Pension, she will get the pension, family pension will get. But that, like lordship, the loss of income till the date of superannuation, that amount will be deducted, cannot be considered. Loss of income, there cannot be considered. But so after that lordship, family pension, that amount
No,
cannot.
suppose your salary is 100,
Lordship, I have
till
given
date of superannuation, you will get 100. And after superannuation, you will have got 50.
50.
So you will also get 50.
Okay.
What is the loss after
Lordship, kindly see the
superannuation?
judgment that I have given, the latest judgment lordship, Supreme Court judgment lordship.
Of same Supreme Court judgment, answer the query. What is the loss? That means you have not understood the Supreme Court judgment if you cannot tell us.
But
What does it say?
for loss under the head of loss is to be taken into
Just
consideration.
clear your own confusion.
Loss is to be taken into consideration. Pension relating
The
to
loss I am asking. What is the loss?
post lordship.
You
Suppose
are getting
if he
whatever your
survive-
husband would have got.
If he survive,
Did not answer the question. You are getting whatever your husband would have got on that head.
if
Loss
he
of income.
survive, suppose lordship, he would have got lordship 100% pension. Now, after superannuation, his family pension will be 50%. And
Who is getting 100% pension?
suppose the person is
Why will you suppose?
the person
What is the pension? 50% of last pay for a government servant.
Yes, that is there. But what will be the family pension? Pension and family pension.
Not family pension. It is the pension he is getting. The normal, go to 5.6 on attaining the age of deemed superannuation, CFP will be converted to normal family pension. Normal family pension shall be fixed at 50%.
Normal family pension, my understanding
That is what he would have got if he had been alive. 50% of last pay.
normal family pension would be the pension lordship that would be entitled to his wife or children lordship. As
Have you
a
read 5.6? Anyway, if you insist on that, you go and agitate that before the tribunal will remand it back in terms of this judgment. You have to show what you were supposed to earn.
and so far other head lordship, your lordship directly release that part of.
We will dispose it of exactly as this one. Establish your loss of future income there before the tribunal. That's
After Supreme Court judgment, your lordship kindly peruse that, the marking part lordship only.
That has been explained. Which one?
set of rules.
Yes,
Covered these 2006 rules.
even recently, my lord Apes was explained that this is under different background, my lord. Apes court has recently distinguished that part of the matter. Of the day question comes, where is the loss? The of double benefit, the question of double benefit comes with the people who were waiting for the misfortune all the time. Said the court's decision clarifies that when calculating compensation, only overlapping or equivalent benefit. Yes, yes. As long as there is an overlap, it will have to be deducted. Yes. These are already clarified, my lord, even recently. Regard to the question of double benefit, my lord, I am taking one decision, your lordship will look at in paragraph 6. My lord. Very short paragraph, paragraph 6. My lord.
Regarding pension, well, that is the entitlement of his family loss. There are some Supreme Court decision to that effect. If your lordship
Pension, you are getting it.
tomorrow lordship, I will place some the husband on pension lordship. There will be loss of income after superannuation.
But it appears some misconception on his part because the notification is very clear.
Read the notification again and decide whether there is any necessity of any further judgments in this regard. The thing you have to tell us is whether do we fix it or do you want to go back there and re-agitate future? Go there, you may have get something more.
You can try his luck.
Yes, you can try your luck. When prove that you would have been promoted. What were you working as? What were you working as?
In police department.
Constable,
Police department.
Assam Police,
Constable. Age? 3 years.
on the date of incident.
You have to go there and show that people similarly situated have been promoted within the next 10 years.
Obliged.
Maybe, lordship, maybe, lordship, tomorrow I will place to judgment regarding on pension lordship. I'll place it.
Not CAV, we are going to pass orders today itself.
Place today itself, lordship.
Yes, pardon?
As per paragraph 20.
By learned counsel.
My lord,
Thing.
I have small submission, my lord. The respondent number 3 that is the plaintiff, he has expired during the pendency of the SLP before the Supreme Court. So I maybe it's legal heirs.
That happened first then. Who died? Who died?
The respondent number 4.
The respondent number 4 has,
I'm sorry, 3.
has
Ramendra
Narayan
Das
has expired on
on 7/9/2024.
the legal heirs. The matter again on since create applications be filed.
Obliged. Well, it's
Number 1, Lordships.
Prayer of learned counsel for the respondent further 3 weeks time is granted. Counsel for respondent number 1 to furnish details regarding the death of the deceased respondent number 1. Again on. Obliged.
Lordship service is complete and can go for final hearing and LCR is also received. As per office.
Learned counsel for the appellant as well as the service is complete. Here has also been received matter for hearing.
That may fix. And the appeals.
Obliged.
Obliged.
Upgradation matter.
Can it be on Lordship 21st of April, Lordship? 1st of April, Lordship. Right.
Are you ready?
I can start if my learned friend takes down notes because
I'll have to inform my.
we'll take some time, my lord. This is an appeal hearing, and this, my lord, and my learned senior friend, my lord, will be aware of my lord, my arguments. We have, my lord, argued it, my lord, several times now. But I leave it.
I'll have to inform the.
Is the hearing list. If we start with one item, then God knows how long it will continue. Let's do one thing. I'll take a short break. We'll come back.
Right. Please, your lordship. This appeal from the order which had dismissed my injunction application before the first court, trial court. What had happened, I'll give the brief facts and then I'll come. The original plaintiff, Barua, owned 861,918 shares in a company. If number 1. For operational convenience, he had transferred it in an account where he was the first named holder and different number 2, who's his daughter, was the second named holder. And this is possible, account depository number knows now all shares are dematerialized. So in a depository participant account, he had transferred it where he was the first named holder and the daughter was the second named holder. Under law, the first named holder is entitled to voting and all that. Then he wanted to transfer the shares to a family trust, which was meant for all his children and his grandchildren. And the shares were bought with his own money. This is also very important because that's how the law takes care of whether if it's bought with his own money or shared money. When he wanted to transfer, when the daughter refused, he filed a suit. A civil suit before the Gauhati District Court. And there was an order of injunction which was passed on 13th August 2012. Directing status quo to be maintained with regard to the shares, which means the shares were in a depository participant account, which is numbered as 3011550. So those shares were to be maintained in that account. That was the order which was passed in 2012. He also left behind a will. A will 17 September 2012, whereby he bequeathed these shares. It's a registered will. He bequeathed these shares to the family trust. And he had a predeceased son's family, which is the daughter-in-law, daughter-in-law's daughter, so grandchild. He had another daughter. He had 2 sons. And he was quite naturally, because the other younger daughter did not refuse to give up the shares in signing the account. So in the will itself, he said this daughter is not entitled to anything. He should not get anything. But naturally, his shares, he put it in first named holder and second named holder. When he wanted to take it back to the trust, she refused and he filed a suit. There was obviously acrimony before he passed away. Then, after filing the suit, after the order was passed, Mr. Barua died. In terms of the will, there is an executor who's really to carry out the wishes of the testator. That's how a will. So then this executor, the name of one Somnath Chatterjee, applied for substitution. He applied also for probate of the will before the Calcutta High Court, and he also applied for substitution in the suit. The substitution was kept on hold, kept in abeyance. The suit was kept in abeyance by an order of the court saying that till you obtain probate, let this substitution be kept in abeyance. And the order which was there 2012 had continued. We came up before civil revision before this court. The other side also came up in civil revision before this court. And both civil revisions were dismissed. So that was the position which was subsisting. Now, while the interim order was going on, they also made some applications which may become relevant because they had gone up to the Honorable Supreme Court before also. So they made some applications saying that the suit has abated. Therefore, there is no suit which is pending, subsisting. This Honorable Court dismissed their application by way of civil revision when they had come up. And the Supreme Court also confirmed it, saying that no, it is kept in abeyance. Then what happened, Lord? Again, this court reviewed the earlier order, which was passed, keeping the suit in abeyance, and said, and this was in 2025, and said that no, let the suit continue till a decree is about to be passed, which may be the correct position now, because that's what after this court said, then the suit started proceeding. And my original application, which was there, because the 2012 interim application where that status quo order was passed, that came up for hearing. And though the other side considered saying there can be an interim order, we really did not argue. The learned district judge dismissed my application by an order of 15 September 2024. 15 September 2025. Civil judge at Gauhati, sorry, I said district court, civil judge at Gauhati dismissed that interim application. I came up in appeal, which is the appeal which is before my lord. And an interim order was passed on 24th September 2025, directing that the shares should not be transferred by the respondent number 2, which means the shares which were lying in the original account where Mr. Barua was the first named holder and the different number 2, the daughter was the second named holder, it should be there. Now, what they did was suppressing this order of 24th September, and that's all on record. They wrote to the different number 3, which is the HDFC Bank where the shares are held, and had it transferred in their name, suppressing the order of 24th September, which was passed by this Honorable Court. Transfer it to their own dematerialized account. But naturally, we came up immediately and said we filed 2 applications. One is under section 151, saying the shares have to go back because there's an order of this court. And we also filed an order 39 rule 2A, saying that it's in violation of the order of this Honorable Court, which are the missed cases which are there. Then that section 151 application which we filed was disposed of by an order of 28 January 2026 by saying that, sorry, you have to reverse the shares. You could not have transferred the shares in view of the interim order which is pending. This is 24th September 2025. So 28 January order was passed saying that you have to put it back into the account as it was existing from 2012. And that is a very detailed order. I'll take my lord through that order as well. So this was on 28 January 2026. Then from that, they preferred a special leave petition. In the special leave petition, that is the order of 5th February 2026, the special leave petition was dismissed. And we prayed on our prayer, because it is our appeal and our suit. We prayed, please expedite it. This appeal as well as the suit. So the Honorable Supreme Court said, very well, we are dismissing the special leave petition, but we are also expediting the appeal and the suit. So this is where we stand. Now, and now what happened after the Honorable Supreme Court's order? Yes. After the Honorable Supreme Court's order, well, naturally we wrote to the bank and we also wrote to them. Now the bank has reversed the shares. Now it has gone back to the original account, which it was at the time of filing of the suit. So the interim order gets restored So it has gone back to the original account, which was in the name of the two persons. And that is where things rest now. Now, my lord, the suit has to be quite naturally tried out. The evidence we are getting ready to have the suit. Now, my first submission is that the interim order which has been passed by this Honorable Court on the 24th of September 2025, which says, you defendant number 2 will not deal with the shares, respondent number 2, your daughter will not deal with the shares, will not transfer the shares, which means that the shares have to remain where they were. And that interim order, in effect, has been affirmed by the Honorable Supreme Court. So the appeal should be disposed of continuing that order, that it should remain in that account which is there, and we should go and have the suit tried out, because that is how I see things would be. Because since it's received the stamp of the Honorable Supreme Court, where, and I'll show there also in the before the Supreme Court also in the special petition, they said no, you could not have directed me to transfer back the shares. You cannot direct me to reverse the shares, because what they say that by operation of law, according to them, by NSDL rules, they say the shares are to be transmitted in my name. And therefore, transmission is not transfer. And therefore, the shares should go in and stand in their name. Now, I think that scope is now gone, because the Supreme Court having affirmed the 28th January 2026 order by dismissing the special petition, that scope, according to me, perhaps is gone. Now, just one more thing, and then I'll show the facts. In India today, the law is, and we have good authority for that, the law is that when you put or when you transfer the shares, when anyone, if I had shares, and if I transferred those shares in the joint names of me and say one of my sons or one of my daughters, it doesn't mean I am giving the shares to that daughter or the son. It's like a nomination. It's like a nomination. Nominee doesn't become the owner of the shares. Like LIC, when we nominate, the conception or the misconception which most of us, or the at least the other people had, was that nomination means that it is given to you. Second holder means it is given to you. That's not the law. The law is that it has to follow, because the only way known.
What is the purpose?
Correct. Sorry.
The purpose of having a second holder?
The purpose of a second holder is to, if there is no dispute, if there's no dispute, then the second holder holds the shares till the real beneficiaries come and claim it. Today, I can be a nominee in any of my learned friends' account, or I can be a second named holder as well. But doesn't mean I get the shares. I'll have to hold it till my learned friends, legal heirs or children come and say, sorry, now give it back to me, you're holding it. That's the purpose. Nomination is also that. But now knows one of the Honorable Supreme Court has, in fact, it's Justice Roy's judgment, who clarifies and lays down the law by saying that, yes, it's the same thing. It's like a LIC nominee. It's like other nominees. You only hold it till the legal heirs are ascertained. Because here, kindly see, the shares all go to a trust. Here, the executor is also not the beneficiary. The executor is to ensure that the shares go to the trust. And the executor now has been substituted. It's an accepted position that he is the executor. He's been substituted. And what the defendant number 2 also tried to do, there's another parallel proceedings in the Calcutta High Court. What they wanted to do is they also made an application there in the Calcutta High Court, saying that you delete this chunk of shares 861,918 equity shares from the testator's estate, which is known as affidavit of assets, you delete it. Calcutta High Court said, sorry, we can't do that. So that order is also there. And so far as the dividends are concerned of the shares, that is being deposited in the executor's, in the testator's account, the estate account. So today the only question is what kind of interim arrangement will be there till the suit is heard out. This is really the subject matter of the appeal today. Now, my lord, I'll just show, kindly first see, if my lord takes IA 3216 of 2025, which is the stay application, because the papers are, documents are there. Kindly, my lord, see first the plaint which starts at page 19.
Yes.
And my lord will find the name of Hemendra Prasad Barua, who was the original plaintiff, the father who had the shares originally. Then BNA Limited is the company. 2 is Shormila Shetty, who's the married daughter, and then 3 is HDFC Bank Limited. Then Malad sees paragraph 4. The plaintiff had 1 son and 2 daughters. The plaintiff's son predeceased him, having died on 2nd October 2007, leaving behind his widow and daughter. The defendant number 2 is one of the married daughters of the plaintiff and is purporting to hold 3162 shares of Sunset fully bearer. This is another bunch of shares which she holds. Defendant number 3 is a depository participant, and one of the depository accounts of the plaintiff is maintained with the defendant number 3, where the defendant number 2 is shown as joint account holder by reason of circumstances stated hereinafter. Then kindly look at paragraph 7. Plaintiff at all material times has been interested in organizing his assets for the benefit of his family members as well as for benefit of the serving charities. By reason of the the plaintiff by a deed of trust dated 5th April 2011 has set up a trust called Hemen Borua Benevolent and Family Trust inter alia for the benefit of his family members, which deed has inter alia been amended on 21st November 2011, writing by a registered document. Then kindly see plaintiff also executed a registered will on 21st November 2011. This is the earlier will by in which the plaintiff's entire shareholding of in the company is answered. Then kindly come to paragraph 10. On 12th November 2008, the plaintiff caused to be opened a demat account with the defendant number 3 and inducted the defendant number 2 as joint holder of such account so that the same could be operated by both the plaintiff and the defendant number 2. And just before paragraph 10, 9 shows where the shares came from, which was a dematerialized account maintained by him in his sole name. That's paragraph 9. Plaintiff at all material times maintained a demat account in ICICI Bank in his sole name. Then kindly come to paragraph 16. Inasmuch as the said 861,918 equity shares of the plaintiff maintained in the joint account of the plaintiff and the defendant number 2 of in the company were acquired by the plaintiff as promoter of the company during public issue of shares pursuant to mergers, as well as purchases from the open markets, entire shareholding as held by the plaintiff was categorized as promoter category shareholding of in the company in the declaration of shareholders of the company. Then kindly come to paragraph 18, very important. This is what the plaintiff says. His intention is very important because he's the one who acquired the shares. Plaintiff submits that 861918 shares deposited / transferred in the demat accounts, wherein the joint names of the plaintiff and the defendant number 2, only for operational convenience, and no beneficial interest in the shares were ever intended to be passed or was passed to the defendant number 2 at any point of time. So this is his statement. The entire dividends declared by the company during 2009, 10 and 11 have been paid to and received only by the plaintiff. Further, the concerned shares have never been shown in the accounting records of defendant number 2. Defendant number 2 is and was at all material times aware of the same, accepted the same and acquiesced therein. Then again paragraph 21, it is repeated. Kindly see paragraph 21. However, it is stated that save and except for the aforesaid operational convenience, no beneficial interest of the shares whatsoever were intended to be passed or was passed to the defendant number 2 at any point of time. Then as stated, entire dividend has been shown in accounting records of plaintiff, not in the accounting records of the defendant number 2. The plaintiff further states the basic reason for introducing the name of the defendant number 2 was to ensure that after the death of the plaintiff, the demat account should not be frozen. The dematerialized account in the name of the plaintiff and the defendant number 2 were only for opened only for the aforesaid reason. However, the plaintiff was and continues to be the sole beneficial shareholder in respect of the company, including the said 861918 equity shares of in the company. Plaintiff is the absolute owner of such shares, entitled to and has received all benefits attached to the said shares, exclusion of the defendant number 2. Defendant 2 is all material terms aware of, accepted the same and acquiesced therein. Defendant 2 is stopped from making any claim to any right, title, and interest said such shares of the defendant number 1. Then, Lord, kindly see what the cause of action comes in. Uh, 23, paragraph 23. Plaintiff is 86 years of age and is keen to organize his assets in terms of his will and the trust to facilitate expeditious resolution of the matter. Plaintiff had sent several communications in the last few months to the defendant number 2 to sign the delivery instruction from the defendant number 2 for transferring the said 861918 shares from the demat account maintained with the defendant number 3 to the demat account in the sole name of the plaintiff. Such transfer is essential for ultimately transferring the said shares to the trust. Such requests made by the plaintiff to the defendant number 2 include verbal and telephonic communications. Defendant number 2, however, refused to sign the delivery instructions. Plaintiff has tried all possible means to persuade the defendant number 2, but the defendant number 2 has not responded to any of the letters communications sent by the plaintiff. The defendant number 2 is also not attending board meetings of the company despite being a whole-time director of the company, such. Then in that context, this suit was filed. Now kindly see paragraph 31 at page 27. That the plaintiff states that the defendant number 2 has failed and neglected to comply with the request of the plaintiff. Plaintiff states that defendant number 2 has no right, title, and interest, benefit, or otherwise in respect of the said 861918 equity shares of in the company. The defendant number 3 has also not been unable, has also been unable to transfer the shares by refusal of defendant number 2 to execute the delivery transaction issue slips. Then kindly see paragraph 41. That the cause of action of the suit arose within the jurisdiction of this court on 22nd August 2011, when the defendant number 2 refused to sign the delivery instruction slip of defendant number 3 in respect of shares of the plaintiff, which are of the defendant number 1 company, having its registered office within the jurisdiction of the court and shares a lying in demat account number. Now kindly see this DPID number 301151. This will find mention in the other orders which I'm going to show in the 2026 orders. DPID number 301151 and client ID such and such, and all subsequent dates on which the defendant to refuse to sign the delivery instruction slip and defendants failed to act on the sole instruction of plaintiff, citers of shares and such. And in that fact, in the relief will find at page 31. Kindly see declaration. Relief, the plaintiff is the sole and absolute owner of 86191 equity shares of the defendant number 1, which is now lying in the demat account bearing DPID 301151 and client ID in the names of the plaintiff and the defendant number 2 maintained by the defendant number 3. Then prayer B, decree for mandatory injunction directing the defendant number 2 to execute, sign the delivery instructions form and to submit the plaintiff for transfer of the said 86191 equity shares, sole name of the plaintiff. Then C is perpetual injunction restraining the defendants from transferring the shares from the existing account. And this is what has been granted. From the existing account maintained by the defendant number 3, save to any demat account standing in the sole name of the plaintiff. And perpetual injunction restraining the defendant number 2 from using the delivery slips lying with defendant number 2 bearing number from such. Then perpetual injunction, E is dealing with, F is mandatory injunction. So this was the suit. And the order which was passed in 2012 we will find that at page 226 of this stay application.
What is the mode in which the transfer is done? Number 3 is the bank.
Sorry, my lord.
Number 3 is the bank.
Yes, yes.
I'm just trying to understand the manner in which the transfer, if made, how it is done.
My lord,
On an application by one of the account holders.
both have to. My lord, if it's both are named, it's like a bank account. The shares these days, my lord knows, is put it in an account which is known as a demat account. It's like a bank account. So there are two names. Now to transfer it, both have to sign, which is known as a depository slip, like a checkbook.
Some depository slips are lying with the defendant number 2.
That's right.
Bearing the signatures of both.
No, not bearing the signature of both. His apprehension was that after he passed away, she might use it to transfer it. Because then she will say, oh, I'm the only one
Surviving.
That's right. And that's exactly what happened in the meantime. As soon as the order was vacated in that window of 15 September 2025 till 24th September 2020, when we obtained the order, and my learned friend suppressed that order. That's on record. That they suppressed it. The bank has come and said, no, we are not aware of the High Court order. So they only use the 15 September 2025 order to say, oh, look, the injunction has gone. The status quo is gone, therefore transfer it in my account. And quickly got that transferred. And
Which has again been reversed.
that which has been reversed. Which has been reversed and affirmed by the Honorable Supreme Court. When I show that order of reversal 28th January, the learned judge said that you suppressed it, you did not disclose to the bank that there's a subsisting order passed by the High Court. So they only showed the Jorhat civil judge order of dismissal of my injunction and did not show the order passed by the High Court. Now, that shows more apprehension on my part. It's more reason why this order has to be continued and those shares have to be protected in that particular account till disposal of the suit. Well, that's absolutely correct. That's how it happens. It's an account where the depository slip you sign And what was happening, my lord, when the plaintiff, who's the first named holder, signed it and told her to sign it, she's saying, I don't sign. Because she did not sign it, the shares could not go back. Could not go back in the sole name of the plaintiff. And I will also show under the articles of association of the company. It was challenged by her in a company petition. My lord knows we have the National Company Law Tribunal where matters of mismanagement, oppression and related to companies comes up there. So they had also filed a company petition challenging the articles of association, in which the article of association says that when there is a case of first named holder and second named holder, the executor will come into the place of the first named holder. And that company petition got dismissed, which means the articles are now sacrosanct. There also they asked for a declaration. No, I am entitled to the shares solely in that company petition, which is now dismissed. So all this has happened. Now, in this, where will the prima facie case balance of convenience? I don't know why the Jorhat court dismissed my interlocutory petition, because I thought it was if the order has been subsisting from 2012, there's no reason that now the trial of the suit is going to start, that you will vacate the interim order and alter the status which was prevailing for all these years. This is not a question of someone, you have to show a right. And the law is very clear on the question of when you have a second named holder, when you have a nominee, that you're not the owner. In fact, I'll just show, just give me the 45, well, just look at the law so that at least, we've given, to have the 45, we've given it to you before. AIR 1945 Privy Council, page 10. Just kindly look at this. The first line itself, in the head note itself, sees the deposit by a Hindu. First page, the first page, para 11 it refers to. Deposit by a Hindu of his money in a bank in the joint names of himself and his wife, and on terms that is payable to either as survivor, does not on his death constitute a gift by him to his wife. There is a resulting trust in his favor in the absence of proof of a contrary intention, there being in India no presumption of an intended advancement in favor of a wife. Relies on 28 Privy Council. Then says next, the rule is not confined to assets in the joint names of the deceased man and his wife. It is of universal application, whatever the property and whatever the relationship. The question of contrary intention is one of fact. And here, the contrary intention is clear on the face of the plaintiff itself. Because all these issues generally arise after the death of someone. And here it started before the gentleman's death.
It's from the horse's mouth.
Yes. Sorry.
It's from the horse's mouth.
Yes, correct. Yes, correct. Horse's mouth, or the author himself says that no, sorry, I bought it, and you have no. So presumption of gift, presumption of ownership, all gone. And only for operational convenience. Correct. That's I've never used that expression, but the plaintiff, when they filed, that's really from the. Now, kindly look at page. So this was the order which was subsisting. So give me the type. The first order which was passed 13th August, the typed copy, my lord, will find at page, it starts at 226, no, 226, which is the original copy of the order. What volume is it? You have one volume. Page 226, my lord, will find 13th August 2012. This is the original order, my lord, which was passed. My lord, there's a better typed copy at page 231. My lord, will find this miscellaneous case is registered on the strength of the order passed on 13th August in title suit 41 of
I think
2012.
231 is a continuation of this.
Yes, my lord.
Starts at 226. 13/8/12.
26.
Page.
Yes, 226 the original order.
Ah.
And the typed copy, my lord, is, though that is also typed, but this is a better copy at 231. It's same order, my lord.
The continuation of the original.
Oh, my lord, then 226, my lord, will find. Huh?
There is any type copy.
Oh, there is no, I'm so sorry. There's no type. Then, my lord, kindly look at 226. I just need to show the first two lines and then the.
This 226 itself is the type copy. I think.
Oh, very well. So, my lord, that is the, my lord, this miscellaneous case, my lord, sees, is registered on the strength of the order passed on 13th August 2012 in TS 41 of 2012 filed by the petitioner plaintiff. Son such, the said order was passed upon the petition order 39 rule 1 and 2. Section 151 of Code of granting ad interim injunction restraining OP and servants, workmen, and such in respect of. Then, my lord, straight away kindly come to the end of the order. Sorry, in the middle, my lord, will find all this story is narrated. The fact with regard to the shares being held by the original plaintiff and then transferred, then kindly see at later koto hobe 231 perhaps, my lord, the end of, my lord, that. My lord, 230 maybe, my lord, the end of the.
The line.
Yes, from the above facts and circumstances. Operative portion of the order, my lord.
33.
236, my lord. From the aforesaid, from the above facts and circumstances, it appears that the parties are disputing the equity shares in the names, so it would not be just to grant ad interim injunction without hearing the other party. However, keeping in view attending facts and circumstances in respect of the joint account maintained in the deposit of opposite party number 3, I am of the opinion that order directing the parties to maintain status quo over the subject matter of the suit, that is the equity share lying with OP number 3 in Malatsis DPID in 301151 and client ID till hearing of this injunction petition would meet the ends of justice. Accordingly, notice be issued calling upon OPs to show cause as to why the ad interim injunction should not be granted. Praise for. Parties are directed to maintain status quo of the subject party till disposal of injunction fixing such. This is the order, my lord, which really continued till, my lord, 2025 when, my lord, the application got to be dismissed. Now, my lord, kindly come to what's the other order? Kept in abeyance. Huh? Now, my lord, page 3.
350 the hand now.
350.
360.
I hope, my lord, I am right on the, it's page. Why are the page numbers? Why are they like much?
Order dated
Uh,
23/12/13.
20,
350 Annex G.
yes, yes,
Handed.
yes, my lord. 23rd December 2013.
Is fixed for orders.
My lord, this was on the substitution application. My lord will find that, hopefully, my lord, again, the pages 359, my lord will find the operative portion. It says, however, instead of dismissing the petition filed by Somnath Chatterjee, the executor of the will, in the will of the sole deceased plaintiff, Hemendra Prasad Borua, following the spirit of judgment in Pinapani Kaur Chaudhary, in such and such, view to do complete justice between the parties, petition filed by Somnath Chatterjee is kept in abeyance. Hazrat, I'm sorry, my lord, I don't know whether, my lord, the pages are.
No, I think it's okay. This is on page 359.
Yes, my lord. Is kept in abeyance. So, my lord, the substitution petition, my lord, got kept in abeyance, my lord, in 2013.
After the plaintiff died, who was sought to be substituted
the
in his
executor.
place? The executor.
Executor. Who is the present appellant here? Because we made an application for substitution. And which was finally allowed in 2025.
For whatever reason, earlier the court was not inclined to allow the.
Not inclined. Then we came up, both came up before this honorable court. And there's an order but which was passed by civil divisions, where both of our civil divisions were dismissed from this order.
Page 370.
Which is at page 370, that is the order of this honorable court. And then on a review of that order, this order, Annexure H.
Page number?
370 it should be. Annexure H. This is an order of 13th November 2014.
And 97 of 14.
It's dealing with both our civil revision petition. Will find at page 371, heard Mr. Sansach, assisted, then heard, then paragraph 2. By filing the civil revision petition under Article 226 of the Constitution of India, should be 227, the petitioner has challenged the order dated, this is the order, 23rd December 2013, passed by the learned civil judge Jorhat in TS, whereby the application filed by the petitioner for substitution of the petitioner in place of the deceased plaintiff has been kept in abeyance. Said TS has also been kept in abeyance. In paragraph 3, respondent number 1 in this case, that is CRP 47 of 2014, has also filed a civil revision petition. CRP number 97, challenging the order dated 23rd December, passed by the learned civil judge, on the ground that the plaint filed by the original plaintiff does not reveal the plaintiff as any locus standi to suit. Trial court ought to have rejected his substitution petition, dispose of this injunction. So both we filed. And at page 379, my lord will find paragraph 22 of the order.
And to interfere.
Yes. Paragraph 21 and 22. My application was kept in abeyance. The suit was also kept in abeyance. We tried, but then. Now, Malad, just on the other side, Malad will find, kindly come to Malad the probate petition which was filed. This Malad will find at page 239. Because I want to show the will. So will, Malad, not only the suit, but the will also. And
After 379, where are you?
Malad, sorry, Malad, after 379, Malad, I'm just taking my lord back to page 239. I'm so sorry. I'm taking my lord back to, because this has also been filed in 2013. After the death. Let's see, it should be annexure D. Well, it says ES 27, 2016, PLA 316 of 2013. In the goods of Hemendra Prasad Borua, son of Sansach, then my lord, humble petition of Somnath Chatterjee, executor of the last will and testament. Dated September 17, 2012, sorry, and subsequent to codicils dated November 19 and February 12, 2013. So this is the probate proceedings. And Malad, very interestingly, quite naturally, everyone else, all the other heirs have given consent for Malad to grant of probate of the will, establish that will, except given number 2. And Malad will find Malad this will at page 256. This is a registered will. Malad says, I, Hemendra Prasad Borua, such and such. Then Malad 1.0 is executor. I hereby appoint Somnath Chatterjee to be my sole executor of this will and my entire estate. Then 1.2. Immediately after my death, the executor shall take into his custody all my assets and properties, including all papers, documents, and protect and preserve them and take expeditious steps for obtaining probate, and give an intimation to Mr. Sansach, period of 3 weeks, that he has elected to execute my will. Then Malad, kindly come to 2.2. Estate. Malad says 2.0, it says heading is estate at page 257. I have 2.1 is I have promoted and or in management and control of BNA Limited, to which I am presently holding 861,918 equity shares constituting 27.80 of total paid up share capital. The said 861,918 number of equity shares of BNA Limited, 2.2, as above are held by me with my daughter Shormila Vijay Shetty, who is the second holder. The entire consideration for acquisition of all shares was paid by me, and no part of such consideration was paid by my daughter, and my daughter has no beneficial interest in such shares. I have applied before the company law board for removal of her name. This was one proceeding which was filed before. In respect of shares which was reportedly disposed of on the ground of lack of jurisdiction. Then kindly see, I have also filed a title suit for declaration in the matter. This is the suit which I showed. I have also filed a title suit for declaration in the matter of said 861,918 numbers of equity shares of BNA Limited before the Honorable Civil Judge Jorhat, and in a petition filed by me arising out of the said suit seeking an interim injunction, Honorable Civil Judge has directed to maintain status quo over the subject matter of title suit till disposal of the injunction application. And then that's on 13th August, which I showed. And then kindly see clause 5.1 at page 262. I give, devise, and bequeath my entire shareholding in BNA Limited, as mentioned in para 2.1 and 2.2 above, being acquired as the promoter during public issue shares of issue of shares from merger as well as purchase from open market exclusively out of my own funds, capital savings for, let's see, Hemen Borua Benevolent and Family Trust, absolutely and forever. And in fact, he was so upset with the daughter that at page 264, my lord will find sorry, my lord, may I just show from 6.1 at page 263 at the bottom of that page? Specific declaration of disinheritance. Well, let's see. I had mentioned in para 2.1 above that I'm holding 861,900 equity share B&A Limited, among others with my daughter Shormila Shetty, who's second holder. Entire consideration of the shares were paid by me. I have filed a title suit for declaration in the matter of said sunset equity shares of B&A Limited in my sole name before Honorable Civil Judge, and the Honorable directed to maintain status quo. Plaintiff and petition filed in the matter is clearly unable to explain my compelling reasoning. By her action, let's see, my younger daughter Shormila Shetty is trying to invade into my right over sunset shares, manifestly acting in illegal and unscrupulous manner to detriment of my conscientious intention of arranging my assets and properties for the benefits. Then she has also got surreptitiously and by playing a fraud got certain shares of B&A Limited transferred from her mother to her name. Now, this is another suit, which is pending. Because there were some shares held by the mother that she got transferred. Such conduct of my daughter as above has pained me immensely, and therefore I hereby declare I disown and disinherit my said daughter from my estate entirely. So this is, my lord, how, and just to, my lord, borrow, my lord, that expression from, it really comes from, couldn't be better evidence. Comes, my lord, from the horse's mouth, so to say, my lord. My lord, this is the will. Now, my lord, kindly see. Now, kindly see, my lord, page 292. And this is, my lord, important because, my lord, in the impugned order, my lord, will find, my lord, the learned, civil judge has said to the contrary that everyone is opposing the will. 292, my lord, sees consent affidavits given. This is, my lord, the daughter-in-law. My lord, the daughter-in-law, my lord, of the predecessor son, and, my lord, the granddaughter. My lord, see the I. Gargi Borua, daughter-in-law of the deceased above named, Hemendra Prasad. Southern such, do hereby solemnly affirm, says I am the mother and natural guardian of Shenaima Borua, who is aged about 16 years. Then paragraph 2, Shenaima is the granddaughter of Hemendra Prasad, deceased. Then, my lord, what is important is, my lord, at paragraphs 3 and 4. The said Hemendra Prasad, deceased above named, executed last will and testament on 17th September, subsequent codicils dated 19 November and 12 February. I say that the mother and natural guardian of Shenaima, I have no objection if the probate is granted to Shomna Chariji, executed named in the last will and testament, as well as codicils and such of the deceased residing at. The consent letter of, my lord, one branch of the family, then, my lord, at 299, my lord will find the other daughter, the elder daughter. At 299, my lord will find, my lord, similar affidavit, my lord, of the elder daughter. I, Anuradha Phale, daughter of the deceased above named, aged about 59 years, son such. Then paragraph 1, 299, my lord. Let's see paragraph 1. It says, I am the daughter of Hemendra Prasad Borua. $299 million. And my lord, similar thing, my lord, said in page 300. That they have no objection. And Gargi, my lord, in his own name has also given, that was for the daughter, that's at page 308. So, my lord is aware, my lord, that today, my lord, you don't need to apply for probate of a will anymore. Because under the Succession Act, my lord, that section 213, my lord, has been deleted. And this was only required, again, my lord knows, my lord, that only in the municipal limits of Calcutta, Bombay and Madras, if there was something, then you needed to apply for probate. Otherwise, probate was also not required. And here, my lord, there's a property, my lord, in Calcutta. That is why the probate was required. Otherwise, the will would have immediately taken effect. Now, my lord, the affidavit of
Probate is not
assets.
required in other places.
No, my lord. Sorry, my lord.
Probate is not required in other places. Some we have so many probate cases here.
My lord, that is, my lord, if you want to have it proved, then it is required. Otherwise, my lord, it is not required. In fact, my lord, in doing a matter, my lord, in
Because just this morning, in the context of another case, I was reading a judgment of the Supreme Court where I found this observation that Bombay and beyond
Correct.
Bombay and Calcutta, it's not required.
Correct.
That's what got me thinking, because we have so many probate cases here.
Probate cases, my lord, generally, and my lord, probate is applied for if you really want to be certain on the question of passing title. Otherwise, my lord, it's not mandatory. Except, my lord, for Bombay, Calcutta, my lord, and this. My lord is absolutely correct. It is that Supreme Court decision. Well, my lord, what happened, my lord, very interestingly, if I may just digress for 1 minute, my lord, someone had a will, my lord, executed, my lord, in Shimla. And the huge tracts of land, this is given to his friend, the person, my lord, who died. And on that basis, my lord, all the properties have been sold. Now there's another will, my lord, which we have applied for probate, my lord, in Calcutta. In Calcutta. And then we come to see, my lord, all the properties have been sold on the basis of that other will. And here, because the property was in Calcutta, we had to apply, my lord, for probate. And they, my lord, dealt with the property, my lord, there. Now, my lord, in affidavit asset, my lord, we'll find page 314. This is, my lord, the affidavit of asset which you have to submit with the probate application. And at 325, my lord, we'll find all these shares are mentioned. At 325, that it includes that 11, they includes that 861,918 shares. Total shares are, my lord, 11 page 325.
Yes.
My lord, 325, sorry, my lord. Starts at 314. And at 325, I'm just showing, my lord, that this is part of the asset itself, the estate itself. Clause 5. Now, my lord, just to show their repeated attempt to try and deal with the shares, because I want that, my lord, interim protection now from my lord to continue till, my lord, the suit is disposed of. In that context, kindly look at, my lord, what they tried, my lord, before the probate court. That order is, my lord, of 20th August 2025, page 335. My lord, sees High Court at Calcutta Testamentary and Intestate Jurisdiction. Then Somnath Chatterjee versus Shormila Shetty, my lord, who's my lord, the defendant. Then kindly see GA number 5 of 2023 is filed. My lord, has that, my lord, page 335.
Yes.
GA number 5 of 2023 is filed by the defendant praying for amendment of affidavit of assets. Basically, this is an application for deletion of 861918 equity shares, which are lying in the demat account bearing number DPIDN 301151 and client ID such and such from the affidavit of asset dated 25th September 2013, praying for further direction to the executor to hand over the monies, dividends accumulated till date, till now in the bank account to the petitioner herein. It is pleaded that the petitioner is the rightful owner of the said equity shares. Draft amendment application is filed also. Affidavits were exchanged. Then, my lord sees, equity shares in question are those in B&A Limited. Shares figured in the will itself. It is the will itself that the testator as well as the present petitioner were the joint holders of those equity shares. However, dispute cropped up between testator and the present petitioner, culminating in a civil suit pending in the court of Civil Judge Jorhat, wherein an order of status quo has been passed. Since these equity shares are disposed of by the instant will, they figure in the affidavit of assets. The proposed deletion, if accepted, will have two effects. Firstly, a probate court will in a roundabout way consider and decide on the title on those shares, holding that these equity shares were not the properties of testator, hence should be deleted from the affidavit assets. It is well settled that probate court exercising testamentary jurisdiction cannot decide on title of any property. Secondly, it is in the will itself that Civil Judge Jorhat passed an order of status quo and the civil suit is pending. This is also admitted in the application itself. A prayer to hand over those shares to the present petitioner would squarely offend the order of status quo itself as admitted. Petitioner, in fact, knowingly in an attempt to disobey the order of status quo. For reasons stated above, GA number 5 of 2023 stands dismissed and disposed. So they also made an effort there to try and see whether they can get the shares. Now, my lord, kindly come to the impugned order. September 2025, which my lord will find at page 380. My lord has that 380. Both sides are represented, heard learned counsel, both sides, peruse case record. Plaintiff filed this paragraph 4, petitioner filed this, plaintiff petitioner filed this petition under order 39, section 151, praying for ad interim temporary injunction. Then, my lord, kindly come to paragraph 7 at page 381. Original petitioner Hemendra Prasad Borua has set up a trust namely, and my lord, this is after the substitution has happened now, because my lord, this court in review, my lord, recall that order of 2013, and my lord, substitution happened, my lord, on 10th July 2025. I did not show that order because my lord, that's the admitted state of affairs. Paragraph 7 holds original petitioner Hemendra Prasad Borua has set up a trust, namely the Hemendra Borua Benevolent and Family Trust, which was registered on 21st November 2011, by which petitioner's entire shareholding of and in the company, that is 947,289 number of equity shares of in the company, have been bequeathed to the said trust absolutely and forever. Then, my lord, will find paragraph 8, the civil judge also notes petitioner has maintained one ICICI demat account, where at 830,315 number of equity shares. And my lord, all that he notes, and then my lord, end of that paragraph, my lord will see 861918 number of equity shares are mentioned.
Then we find that in paragraph 11, he refers to the NSDL rules. At page 385, paragraph 11. Then paragraph 13, very important. On the page 386, on the other hand, learned counsel for the OP number 2 has submitted OP number 2 has no objection in granting injunction restraining the OP number 2 from transferring the aforesaid shares. There was a concession by them. And then kindly see paragraph 14, considering the materials where submission learned counsel for the parties. Then paragraph 15. Sorry, paragraph 14, may I read that? I'm just reading that. Paragraph 14, I think I should read it. Considering the materials as well as submission of the learned counsel for both sides, it appears that the petitioner side is the joint owner of 861918 number of equity shares with OP number 2. It is also seen from the pleadings of the petitioner that even on request of petitioner, opposite party number 3 refused to accept delivery instruction on ground that signature of the second holder, that is OP number 2, was missing. Thus, under the given circumstances, it appears that one of the joint holders of the account alone cannot transfer the shares. At the time of filing of this petition, Order 39, Rule 1 and 2 of the CPC, both the joint account holders were alive. Thus, cause of action for filing this petition for restraining OP number 2 from transferring the shares had not arisen at the time of filing of this petition. In other words, petitioner did not have a prima facie case at the time of filing of the petition. I'm with great respect, my lord, to the civil judge, my lord, to the learned civil judge. Then 15, during the pendency of this miscellaneous case, original petitioner Hemendra Prasad Borua was one of the joint account holders that expired. Accordingly, as per Rule 12.6.1 of NSDL rules and bylaws, opposite party number 2 was empowered to transfer that said shares to another demat account in her name. In exercise of the powers conferred under Section 26, Depositories Participant, Depository Act, such. Then paragraph 17 says that cannot issue orders which are, I don't know how it becomes contrary because it's a disputed shares. Then kindly see paragraph 19, very important. Mere submission of the learned counsel, at page 388. Mere submission of the learned counsel for the opposite party that opposite party 2 has no objection in restraining her from transferring the shares, as it will not affect the opposite party because the opposite party 2 is not going to transfer the shares otherwise also, is not sufficient to override and express legal policy. Hence, in view of the facts and circumstances case, I hold that the petitioner has no prima facie case. And paragraph 20, I think Milord has lunch.
We're up to 19, para 19.
Yes, Milord. Milord, then I'll.
Item number 20. I have instructed by my client to
Counsel for
kept on record as marking as X and Y, Lordship.
has been compromised. Matter has already been compromised. Marked as Exhibit Act. Learned counsel if to withdraw the did you
It may be fixed, Lordship.
you tell them what did you like?
Item number 20 is
Yes.
19. The claimant is
All right, you give them the dates.
State resolution. Well, we were at page 389, 388, sorry, 388.
P88, my lord. Paragraph 17, it starts from paragraph 3, page 387. I was reading that. NSDL operates under the Depositories Act and is regulated by SEBI, meaning its rules and bylaws of statutory backing. Principle of the rule of law ensures that all actions and decisions, including those by the judiciary, must adhere to the existing legal framework. Court cannot arbitrarily issue an order that contradicts established laws or regulations. Thus, while court has the authority to issue orders, it must do so within an established legal framework, which includes the Depository Act and the rules and regulations framed under it. 18. In the case in hand where NSDL rules has clearly empowered the surviving holder of the demat account to transfer the shares to another demat, to another account in a name, there is no scope of restraining her in direct contravention of express rule, thus seeking remedy against an established legal position in this fact skeptic court cannot be termed as ever existence or prima facie case. Well, I'll just make my submission after read the whole thing. Mere submission of the learned counsel for the opposite party number 2 that he has no objection in restraining her from transferring the shares, as it will not affect the OP because the OP is not going to transfer the shares otherwise also, is not sufficient to override an express legal policy. Hence, in view of the facts and circumstances of the case, I hold that the petitioner has no prima facie case. Then 20, it is submitted that the said shares were paid up and purchased by the petitioner alone, and only for the purpose of administrative convenience, OP number 2 was taken as joint owner of the said shares. The said facts will come out only on trial. I don't know why Mulad he says so. It is evident, Mulad, from the plaint itself. Another important fact as noticed from the pleadings of the petitioner is that the 947289 number of shares which were bequeathed to the trust were not transferred to the joint account of the original petitioner with OP number 2. That was one of the grievance. The shares which were maintained in a separate account of the petitioner in ICICI Bank were only transferred to that joint account. OP number 2 is one of the children of the original petitioner. Other children, now let's kindly see how wrong the learned judge goes. Other children or the legal heirs have not challenged the right of OP number 2 in respect of this 861918 number of shares of her joint account. As the said 86191 number of shares are not the trust properties. This is also wrong. I hold that balance of convenience also does not lie in favor of the present petitioner. Subject matter of the suit are some shares of B&A company. Thus, if the injunction as prayed for is not granted, petitioner would not suffer irreparable loss, which cannot be compensated in terms of money. Great respect, my lord. The learned judge has completely gone haywire, if I may use the expression. Considering the aforesaid facts, I am not found a fit case for grant of injunction restraining OP number 2 from transferring in any manner 861918 number of shares of B&A Limited, lying with OP number 3 in its account bearing number and such, client ID, or restraining the OP number 2 from transferring the 861918 shares, account OD client ID. Hence, the prayer for injunction rejected. Accordingly, status quo order dated 18th August 2012, which is 13th August, stands vacated. Misdemeanor is dismissed on contest.
But 3 submissions, my lord, I make, my lord, approval of this order. First, the learned civil judge, my lord, seems to be swayed by the provisions of the Depositories Act and the NSDL rules. Now, that is in a situation where, my lord, the shares are not challenged. It is merely, my lord, collection. My lord, my lord asked me what is the purpose of there being a joint or a second named holder. What is the purpose? The purpose is for collection, if it is undisputed. NSDL rules will come in only when it is undisputed. It is not an undisputed. Here, the person who transferred the shares is saying, sorry, I did not intend you, the second named holder, to have any interest. And 45 Privy Council note that I showed, I'll also show later subsequent Supreme Courts, which says the same thing. It is the intention of the person who has the shares to show whether it is a gift or not. The person, the donee, person who's received it, cannot come and say, no, it is mine. It is the person who has given, he has to say whether it was his intention to give in or not. I would, with great respect, submit, this is really, in the suit, it should be an open and shut case. Because the donor, in his lifetime has said, I did not mean to give it to her at all. Because there's no dispute, the shares were purchased with his money. And registered will, suit filed during his lifetime, will executed, registered will executed during his lifetime, and referring to the plain and the injunction order. And now, so that's where the first point, the learned judge went wrong. In saying that the Depositories Participant Act and the NSDL rules will override succession. And I'll show again a Supreme Court of authored by Justice Rishikesh Roy where in deciding on the question of nomination, he said Depositories Participant can't override. NSDL rules can't override law of succession. That's so first point he goes wrong. Secondly, they themselves, the other side came and says, very well, we are not going to transfer. That's paragraph 13 I showed, that's recorded. Learned Judge still says, even if you are saying not to transfer, then also I will not pass the injunction and dismiss your petition. That's second. Third, would have seen that the learned judge holds that no one has opposed our entitlement to the shares. With great respect, I don't know how he gets that. The will says it has to go to the trust. The will is supported by all the other heirs. The daughter-in-law, the granddaughter from the predeceased son, the other daughter, everyone is saying, no, it has to go to the family trust. And the learned judge here holds at paragraph C's, that page 389 I pointed out, part of paragraph 20. He says, other children or the legal heirs have not challenged the right of OP2 in respect of those 8619 shares, which is wrong. Totally wrong. As the said 861 number of shares are not the trust properties, again wrong. I hold that the balance of convenience also does not lie in favor of the present petition. And fourth ground of challenge.
On the third ground that this was not trust property.
Yes, my lord, that is wrong. My lord, I'm saying, my lord, the fact that others have not challenged and, my lord, it is not trust property are both wrong. Wrong finding, my lord, of the learned judge. Well, I've shown, my lord, I've shown the will which says trust property. I've shown the bequest clause and I've shown all the other heirs are supporting. Supporting, my lord, by filing a no objection to grant of probate of the will. By filing affidavits, my lord, in that matter.
Not trust property in the sense that as long as the probate materialize, the heirs don't get transferred to the trust.
Yes, quite naturally. But my lord, the fact of the matter is, my lord, it has been imposed or impressed with the trust by saying it has to go to the trust. And fourthly, my lord, there was no reason, my lord, why, my lord, the learned judge would have disturbed the position which was prevailing from 2012, from the date of, my lord, filing of the suit. This interim order, my lord, has survived, my lord, 3 times to the Supreme Court, including, my lord, the last time, my lord, when they went to the Supreme Court.
Now, my lord, from this we preferred the appeal, and my lord will find, my lord, the order which was passed. My lord, in the the reply affidavit which we have filed, or the rejoinder, my lord, can I use it after reply? My lord, it's page 1212. So that order, my lord, petition was dismissed on the 15th of September.
As against the this order, there is an order of the High Court.
Yes, my lord, this is the appeal which my lord is hearing.
Yes.
So we, my lord, preferred, my lord, FA 62. FAO 62 is, my lord, the appeal which my lord is hearing. So we
It has
came
been
up,
passed in the main appeal or in the.
my lord, in the stay petition, my lord. We have annexed it, my lord, at page 1212, or in the stay petition. Sorry, not in the stay petition, the reply to the stay petition. Rejoinder, or
Objection.
rejoinder, my lord, to the objection.
Is in the IA or in the.
My lord, in the IA.
IA
3982.
3216.
16 controls. Yeah, this is 3216.
Yes, my lord, there should be. Hey, no, no.
Order dated.
My lord, order dated 24th September 2024.
1212.
Okay.
24th September
24th September.
25.
Yes.
The present appeal.
Which is, my lord, in the present appeal. My lord sees.
Yes.
Heard Mr. Sunsach, learned Sunsach, and also Mr. D. Mazumdar issue notice. No formal notice is required to be sent to the respondent to us. Mr. Mazumdar is accepted. Extra copy memo shall be provided. Sunsach list 4 weeks. I have heard, I have heard the learned counsel for both sides in the matter of prayer for an interim order. I have considered the submission made by learned counsel for both sides, and I have also gone through the impugned judgment passed by the learned civil judge Jorhat. It is hereby directed, let's see, that till returnable date, the respondent number 2 shall not transfer 861, this was corrected later, 861,918 equities of BNN Limited lying with the opposite party number 3. But will recall, Mala, this was lying in the depository account which I showed, said Mala 3011 300115. Since Mala 2012, so the order is not to transfer, for the respondent to not to transfer. Now at page 1217, this order, my lord, is continued on 9 December. List this matter again on 8 January 1218. Then my lord sees the order of 8th January at 1220. Now, by this time, my lord, what happened? They had transferred the shares to their own account. And that is, my lord, what is recorded on the 8th of January. At page 1220.
Which IA?
Same, my lord, that same, my lord, where my lord saw that 1212, my lord, that same.
This IA ends at page 390. Nothing further is there. The last order.
I'm sorry, my lord. 390. Then, my lord, kindly look at 1212. I'm sorry, my lord.
Yes, page number
1212, my lord. That's an order of 24th September 2025. Which is, my lord, the order, my lord, in the present appeal. The stay application in the present appeal, my lord, that is the order which was passed.
24/9 that
Yes.
we have seen, yes.
My lord has seen that.
That's available in the order sheet. It's-
Oh, I'm sorry, my lord, saw from the, that's why, my lord, I didn't. Then, my lord, kindly come to, my lord, then 1-2, in that same, my lord, 1217, my lord, is 9th December, where the order is continued. Then I was showing, my lord, 1220. This is an order of 8 January 2026. This should also be there, my lord, in the order sheet, but I'm just showing, my lord, here where we're next it. Heard Mr. Sansaz, paragraph 1, then 2, written objection filed by the respondent 2 against the incident application filed by the appellant is placed on record. I have heard the learned counsel for all the parties on the prayer made in the instant interlocutory application for reversal of the transfer of 861,918 number of shares of the company of B&A Limited from the account of respondent number 2 to the earlier demat account of 301151. That is the account which was held by late Hemendra Prasad Borua and the respondent number 2 Shomila Vijay Shetty prior to the said transfer. Let this case be listed on 20th January 2026. Names of Sansaz should be reflected. Then, my lord, kindly look at the order of 20th January, very important. Page 1223, my lord, will find that order. Paragraph 2. The interlocutory application has been filed by the applicant appellant, Mr. Chariji, under section 151 of the Code of Civil Procedure 1908, praying for a direction to respondent number 3 for reversion of illegal transfer of 861,918 numbers of equity shares from the joint account of deceased Hemendra Prasad Borua and respondent number 2 Shomila Vijay Shetty to the account of respondent number 2 in violation of the order dated 24th September 2025, passed by this court in Civil Appeal 3216 of 2025 arising out of FAO 62. The facts relevant for consideration of the instant interlocutory application in brief are that the present applicant claims to be the executor of the estate of late Hemendra Prasad Borua, who left behind his last registered will dated September 17. As per clause 2.1 of the aforesaid will, the 861,918 numbers of equity shares of respondent 1 company, namely B&A Limited, which was held by the deceased Hemendra Prasad Borua as the first named holder along with respondent number 2 as the second named holder, have been bequeathed to a family trust known as Hemendra Borua Benevolent and Family Trust. I've shown all of these clauses. The present applicant, who is the executor of the aforesaid will, also filed a probate application before the Calcutta High Court for grant of probate in respect of the last will of the deceased Hemendra Prasad. The said probate application is presently pending before the Calcutta High Court. Then 5. Respondent number 2, who is the daughter of late Hemendra Prasad, opposing grant of probate before Calcutta High Court in the aforesaid title suit. Before his death on July 31, 2013, deceased Hemendra Prasad had filed a title suit before the court of the learned civil judge Jorhat, praying for declaration he is the sole and absolute owner of 861,918 shares. Then, my lord, kindly we can skip over, my lord, the rest of that paragraph because I've shown the suit. Then, my lord, paragraph 7, it records, my lord, why the suit, my lord, was the reason given in the suit. Then kindly see paragraph 9, page 1226. In the aforesaid miscellaneous case, initially by order dated 13th August 2012, my lord, I've shown this order, the trial court directed both the parties to maintain status quo in respect of the subject matter of suit. However, by order dated 15th September 2025, trial court dismissed the injunction application and vacated the order of status quo which was granted earlier. Being agreed by the order of in rejection of the temporary injunction passed by the trial court on 15th September, the applicant have preferred the connected first appeal against order, that is FAO. In the aforesaid FAO, the applicant has also filed an interlocutory application order under Order 39 Rule 1 to read with Section 151, which has been registered as interlocutory application 3216. In the aforesaid interlocutory application, by its order dated 24th September 2025, the court directed respondent number 2 not to transfer the 816,918 numbers of equity shares of B&A Limited lying with opposite party number 3 till the next returnable. Restraint order was extended by this court on the next day, that is 1911, till next date, and same is still in force. It is also contended by the applicant that a copy of the restraint order dated 24th September was served and delivered upon respondent number 3 HDFC Bank on 20th October. However, despite the receipt of the aforesaid order, it is alleged that respondent number 3, in collusion with respondent number 2, have transferred the entire chunk of 861,918 share numbers of equity shares from DPID to DPIDN, which is in exclusive name of respondent number 2. The applicant has also filed another application under Order 39 Rule 2A of the Code of Civil Procedure 1908 against the respondent numbers 2 and 3 for violation and disobedience of order dated 24th September passed by this court. The said interlocutory application has been registered as IS Civil 3982 of 2025. whereas the instant interlocutory application has been filed by the applicant for reversal of the aforesaid equity shares to its original account number, that is DPID 301151, from where it has been transferred to DPID 30476 in violation of the court's order. Then Mr. Sansa, learned counsel, appearing for the applicant, submitted court in its order 24th September. IA had directed the respondent to not to transfer, lying with the opposite party. He submits that the shares were lying in DPID 301151, which was the name of deceased Hemendra Prasad, as the first holder. This one to a second. However, in spite of instant order, then my lord, my submissions are recorded. Paragraph 15. This is very important. He submits that though the respondent number 2 communicate to the bank, and this is on affidavit, my lord, I'll show that, communicated to the bank regarding order dated 15 September 2025, passed by the trial court in miscellaneous case number 27 of 2012. However, she deliberately suppressed the order dated 24th September, which is apparent from the affidavit filed by the respondent number 3 bank in the probate proceedings before the Calcutta High Court. That affidavit is also on record, my lord, before my lord. And this is what's taken note of. The learned senior counsel appearing for the appellant has submitted respondent numbers 2 and 3 have committed willful deliberate disobedience of the order dated 24th. Hence, the applicant has also filed an application before this court under order 39. Then, my lord, 17 learned senior counsel for appellant filed by the Sansaj. High Court has submitted. So, for the presence and taking advantage. Then, my lord, we can skip over and kindly come to paragraph 19, my lord, the prayer to put it back. Then straight away kindly come to paragraph 23 is my learned friend's submission, where, my lord, it is said, he says that no, it is only transmission and not transfer. Then paragraph 28, he says further submits that on the death of joint account holder by operation of bylaws 9.10.1 of the bylaws of the NSDL, the transmission of security in the event of death of a joint account holder takes place in favor of surviving account holder. Then 29, he further submits transfer and transmission of shares are two separate concepts. Same is dealt with by section 56. Submits the section 56(1) deals with the procedure of transfer of shares, one shareholder to another person. Whereas section 56(2) of the said act deals with concept of transmission of shares which occurs due to happening of certain contingencies by operation of law. Then, my lord, his submission are made with regard to how the status quo has not been violated. Then kindly come to paragraph 37, page 1235. I have considered the submission made by learned counsel for all the parties. I have also gone through the materials available on record as well as the rulings cited by the learned counsel for all the parties in support of their respective submissions. On perusal of the materials available on record, it is clear that in respect of 861,918 numbers of equity shares of respondent number 1 company, presently there are 2 title suits pending in 2 different courts. First one is pending in the court of the learned civil judge, Jorhat, that is title suit number 41 of 2012, wherein the release of declaration of the plaintiff deceased late Hemendra Prasad Buru is the sole and absolute owner of 861,918 numbers of equity shares lying in demat account bearing 301151 in the names of Hemendra Prasad Buru and defendant number 2 maintained by respondent through has been claimed amongst other release. Second suit, that is testamentary suit 27 of 2016, which is pending before the High Court of Calcutta, has been filed by the present applicant seeking grant of probate in respect of the last will of late Hemendra Prasad Buru, whereby he has bequeathed the aforementioned equity shares to the Hemen Buru Benevolent and Family Trust. It also appears that though the respondent number 2, after the death of late Hemendra Prasad Buru, had filed an application for transmission of the above-mentioned equity shares in the demat account exclusively held by her way back on 26th October 2013, however, due to the status quo order granted by the trial court, is miscellaneous case number 27 of 2012, in the aforesaid title suit, the respondent number 3 did not transmit the said shares to the demat account of the respondent number 2. It also appears that though by the order dated 15 September 2025, passed by trial court in miscellaneous case number 27 of 2012, the temporary injunction application of the applicant was dismissed and the status quo order was vacated. However, when the said order was impugned by the applicant in the connected FAO, this court by its order dated 24th September 2025, passed in IS civil number 3216, directed the respondent number 2 not to transfer 816918 number of equity shares of BNL Limited lying with respondent 3. It appears that on the day when the restraint order was passed, the aforesaid equity shares were lying with respondent number 3 bank in demat account 301151, held in the joint name of Hemendra Prasad Borua and respondent number 2. It also appears from the submission made by the learned counsel for the respondent number 3, as well as the averments made in interlocutory application number 4154 filed by the respondent number 3 bank, that the request for transmission of the aforementioned equity shares from DP 301151 to DP 300476 was made by the respondent number 2 to the Sandoz House branch of respondent number 3 at Mumbai on 7 November 2025. While, kindly see, very important, while making the said request, though the bank was informed regarding the order dated 15 September, passed in miscellaneous case number 27, however, no intimation was given to the bank by the respondent number 2 regarding the ad interim order dated 24th September 2025, passed by this court in IA number, which prima facie appears to be an act of suppression of material facts. It also appears that though the bank had initiated the transmission of aforesaid shares on the basis of request made by the respondent 2, however, later on, after coming to know about the order dated 24th September, it put on hold the transmission of the aforesaid shares. Then Black's Law Dictionary defines the word transfer as any mode of disposing of or parting with an asset or an interest in an asset, including a gift, payment of money, release, lease, or creation of any document. Also said term embraces every method, direct or indirect, absolute or conditional, voluntary, and such, any interest. Then 44. If the said meaning of the word transfer is defined in Black's Law Dictionary is taken into consideration, act of even transmission of 861918 shares of BNA from DPID 301151 to DPID 30046 would amount to a transfer in violation of the restraint order dated 24th September. Since the applicant has also filed another application, IA Civil 3982 under Order 39 Rule 2A of the Code of Civil Procedure 1908, plea of the respondent 2 that as per the bylaws and rules of NSDL, phrase transmission of security, transfer of security carries different meanings, may be examined in the said interlocutory application. Now, I don't know, my lord, how now the interlocutory application, whether, my lord, it's still relevant in view of, my lord, since my lord is hearing the appeal. That's my application. However, as apparently it appears that the respondent 2 in a request made on 7 November to the respondent 3 had suppressed the order dated 24th September 2025. This court is of considered opinion that even the process of transmission of the aforesaid shares from 301151 to DPID 300476 would amount to a transfer in violation of the restraint order dated 24th passed by court. The plea of the learned counsel for respondent 3 regarding violation of the mandate for taking steps by issuance of notice when time prescribed order 39 may also be considered while considering IA 3982 under order 39.2. Under the circumstances discussed in the foregoing paragraphs, this court is of considered opinion that until the IA civil numbers and such under order 39 rule 2 of the Code of Civil Procedure is decided, court is bound to set the wrong right, which is apparent from records. Accordingly, respondent number 3 bank is hereby directed to revert the 861918 numbers of equity shares of BNA Limited Company from the demat account of respondent number 2 bearing ID 300476 to the demat account of the late Hemendra Prasad Borua, Somela Vijay Shetty, client ID immediately with the above introduction accordingly. Now, my lord, from this, my lord, they preferred a special leave petition. That, my lord, is also there. My lord will find, my lord, at page 1241. The special leave petition is there. And kindly look at kindly come to the grounds. 1241, my lord, will find, my lord, the special leave petition starts. And kindly come to, my lord, 1307, where the grounds are taken in the special leave petition. What was the ground of, my lord, complaint before the Honorable Supreme Court? 1307, my lord.
Yes.
Kindly see, leave to appeal is sought for on the following grounds. This is, my lord, from my lord's order of, my lord, this court's order, my lord, of 28 January. Because the Honorable High Court, while passing the impugned judgment and order dated 28 January 2026, failed to appreciate the settled legal distinction between transfer and transmission of shares as recognized by Company Act of 2013. Thus, the Honorable High Court had proceeded on an erroneous premises that the transmission of jointly held equity shares from joint account of the first and second holder to the second holder's account after the demise of first holder amounted to transfer of shares. Direct ground taken. Because the Honorable High Court proceeded to allow IA number 3983 without adverting to the fact that the Honorable High Court by its earlier order dated 24th September 2025 had merely directed the instant petitioner not to transfer 81691 equity shares of the respondent company lying with the respondent bank until the next returnable date and had not issued any restraint whatsoever in respect of the transmission of the said shares. So this is the defense, my lord, which they took then. And, my lord, now also, my lord, that's the defense, my lord, which they take. I don't know how much survives now. Then, my lord, says C, because the Companies Act in section 56 as well as in table F has given completely different meaning to the transfer and transmission of shares. Clause 23I of table F of the Act gives meaning to the transmission as having title over the shares by survivor after death of a... Now, can you see as having title over the shares by the survivor after death of a joint holder or by nominees or legal representative case of sole in case of death of sole holder. Whereas clause 19 mentions transfer of shares, which is simply transfer of shares between transfer and transferee. Then, my lord, they set out transmission of securities, D, clause 9 point, because clause 9.10 of bylaws of National Securities Depositors Limited, as amended on June, framed in excess of power conferred under section 26 of the Deposit Act, also defines transmission of securities similar to provisions of Companies Act, is incorporated thereunder. Then, my lord, this is set out. And then kindly see, my lord, at page 1311, round J. Because the Honorable High Court, however, in the impugned order took a wrong view that there was suppression of fact by the petitioner, not pointing about the subsequent order of the High Court, while informing the bank about revocation of the status quo order. There was no suppression of facts at all. It was the bank who wanted the revocation. I've never heard this, Mullah. The bank would want, Mullah, revocation of the status quo order, and accordingly the same was submitted. I see, Mullah, they stand before the Honorable Supreme Court saying the bank, this is J, Mullah. I'm reading, Mullah, page 1311.
Yes.
J, my lord, because the High Court, however, in the impugned judgment took a wrong view that there was suppression of facts by the petitioner in not pointing out about the subsequent order of the High Court while informing the bank about revocation of the status quo order, which is, my lord, 15th September, my lord, saw that. There was no suppression of facts at all. It was the bank who wanted the revocation of status quo order, and accordingly the same was submitted. And the Honorable High Court's order was only against the petitioner not to transfer the shares, and the same had nothing to do with transmission. Moreover, bank was very much aware of the said order prior to transmission. And, my lord, K is also important because the High Court failed to consider that the incident petitioner is a joint shareholder of 861918 equity shares, and the mere transmission of the said shares from the joint demat account to the petitioner's demat account only enables her, then kindly see, my lord, the hidden agenda, exercise voting rights and her participation in the company's affairs. Such transmission neither entitles the incident petitioner to receive dividends nor confers an additional benefit, as the petitioner's demat account stood frozen so as to preventing transfer of the shares. Then, in fact, the petitioner had, in fact, event furnished an undertaking before the Honorable Gauhati High Court not to transfer the 861918 shares. Any third party, respondent bank being fully aware, subsisting restraint on transfer, affected the freezing of the petitioner account accordingly. Transfer of jointly held equity shares, the petitioner's demat account, neither creates nor confers, answer 38%. Then, my lord, then kindly see then, my lord, 13 how does it? Paragraph O, my lord, ground O at page 1313 and 1314, my lord, will find in the middle, my lord, it says the third line at 1314. It is needless to mention again that ex parte status quo was passed, though in different intent and context, in an application seeking restraining the petitioner from transferring the shares in question, but the same was being used by the respondent since 2013 to disentitle the petitioner from a legitimate right over the shares, which admittedly she owns as joint owner. The ground, my lord, they take. The reason is well known that the respondent one does not want the petitioner to take part in the affairs of the company so that he can run the company according to his whims and fancies. Then P is because the entire chunk of 861 shares of respondent lying to the account of respondent bank are being held by the petitioner and late Bodua jointly, first named holder, then relies on bylaws of national NSDL. Then, my lord, kindly look at, my lord, the Supreme Court order, which is at 1320. They prefer, my lord, the special leave petition. These, my lord, at the top, my lord, will find arising out of the impugned final judgment and order dated 28 January. Sorry, my lord, 1320. Because, my lord, it's our appeal and our suit. We only prayed for, my lord, that the fact that, my lord, it can be expedited. So while we are not inclined to interfere with the impugned order passed by the High Court, we direct that the FAO and the suit shall be decided expeditiously. Needless to say, observation made in the impugned order will have no bearing on subsequent proceedings. Quite naturally, my lord, that's the law. With those observations, the special leave petition is dismissed. And, my lord, see that 1320 at the top, my lord, this is from the order of 28 January 2026. My lord, again, my lord, three things I just want to point out. First, my lord, the order of 28 January 2026 interprets the order of 24th September 2025, which was passed. That's, my lord, when we came up, my lord, and obtained, my lord, that interim order. And says not to transfer means not transfer from the account where it was lying, which is the other bank account, so to say, the other, my lord, account where, my lord, the two named holders were there. The status quo order also meant that. That's why it was never transferred. And when status quo got dismissed on 15th September, this honorable court also passed an order saying respondent number 2 will not transfer the shares, which meant it should continue in that same account. And also 28th January held in deciding that you have suppressed, and that's a categorical finding. You have suppressed the subsequent order of the High Court of 24th September when you made the bank have it transmitted, because they go on saying, oh, it's not transfer, it's transmission. But the fact of the matter is, my lord, it is going from an account with two names to an account of one name. So it should, and that's what, my lord, my prayer is also, and would be at the end of, my lord, my submission, that it should continue to be, my lord, where it is. And it should continue to be, my lord, in the name of both. And that is now, my lord, also affirmed by the Honorable Supreme Court, because all these grounds they took, they said, no, it is not transfer, it is actually transmission. I am not allowed to exercise my voting right. You do not have any voting right. It's not your share. All these were rejected, and, my lord, the special leave petition was dismissed, with the direction that, my lord, the appeal and the suit, my lord, stands both expedited. Now, after, my lord, the order of the Honorable Supreme Court, my lord, this gets reversed. Finally, my lord will find that, my lord, at 1326, No, 1326. 1326, my lord, is the order after that. We complained, my lord, on 12th February that the order was not complied with up until then. And then, my lord, kindly look at 1328. February 17, 2026, 1328. At the top, my lord, will find Baljit Kaur, HDFC Bank. Date 17 February, subject, immediate compliance required. My lord, has that, my lord? Sorry. Non-implementation of Gauhati High Court order dated 20th January, affirmed by the Supreme Court on 5th February. Reversion of 861 equity shares. Then, my lord, to Sergeant Sarge, the company. Then, my lord says, Dear Ms. Pandey, greetings of the day. As per order, we have processed the transaction from demat account DPID 300476, client ID such to, that's my lord, the respond number 2's, the different number 2's account, to target DPID 301151. This is my lord, the joint. Quantity 861918 and status of for transaction is settled. So 17 February, my lord, finally, my lord, it comes back to, my lord, the original account where it was. So this is, my lord, where we stand so far as, my lord, this appeal is concerned. And becomes important because subsequent to the appeal, my lord, also certain things have happened. And which, in my most humble submission, my lord, will also have a bearing, apart from the merits of the appeal itself, which will also have a bearing on, my lord, as to whether, my lord, that interim order, my lord, which has been subsisting from 2012, should be continued or not for the purpose of, my lord, having now the suit tried. And I am showing, my lord, this repeated attempt because I have to show, my lord, today, prima facie case, balance of convenience, and, my lord, my apprehension. On prima facie case, my lord, I am showing that the person himself said that the shares belong to me. I couldn't have better proof of that. Will says it goes to the trust. Balance of convenience, the order has been there from 2012. And also the repeated attempt by the different number 2 to have it transferred to her account and to try and exercise rights in respect of the shares, which is writ large. First, they tried in the Calcutta High Court saying that you please delete it and hand it over. My lord, I showed the praise. Calcutta High Court said nothing doing. There's already a suit pending. We can't do that. Again, when Jorhat dismissed, though I got an order here on 24th September, you suppress that and try to get it transferred. Or rather, you have it transferred. And then I have to go through another 2 applications, 3 orders, right up to the Supreme Court to oppose you. Try and get it back, which I got it back. But with great respect, my lord, that's the order, my lord, which should continue. Now, my lord, kindly look at very interesting thing. My lord, the account opening form, which is at 1434. And we had put this on record, my lord. We had, in fact, my lord, handed it over at the time of hearing also. This is, my lord, the original account opening form, where, my lord, which now stands admitted also, my lord, that first named holder, my lord, will find, my lord, Hemendra Prasad Borua. And, my lord, the second named holder at page, my lord, 1435, my lord, will find is Shormila Shetty. At 14345, my lord, will find that. So, my lord, we'll recall, my lord, in the will also, and my lord, in the other proceeding also, my lord, kindly, my lord, look at now one, not in the will, my lord, the will didn't mention this. There, another attempt which they made. Why I'm saying, my lord, the interim order is very important for us. My lord, kindly look at now, my lord, at page 1438. This is, my lord, a company petition which they filed in, my lord, we'll see 2013, at the same time when the suit was filed.
Yes.
1438, my lord, will kindly see before the Company Law Board, Kolkata bench at Kolkata, company petition number 186 of 2013, and my lord says Shormila Shetty, petitioner. This was, my lord, even prior to, my lord, the National Company Law Tribunal coming in.
Seeking what?
Sorry, my lord.
Seeking what?
Yes. Absolutely. I'm so grateful. Kindly come to, my lord, straight away the prayers. 1472. One four seven two. My lord has that, my lord. 1472.
72.
172. 1471, my lord, can come. At the bottom, my lord, will find relief sought. Part of the same petition. 1471. Relief sought. And then, my lord, will turn over the page and see, my lord, prayer A. And here petitioner, my lord, is the defendant number 2. My lord, Shormila Shetty. And the same says, declaration that the petitioner is the sole and absolute owner of 861,918 shares held in demat account number 301151 client ID maintained with HDFC Bank. So how many attempts, my lord, will I have to resist with great respect? And this was, my lord, a company petition filed, my lord, in 2013. And, my lord, this petition, my lord, was dismissed, my lord, by order dated 13 July 2017, which, my lord, will find, my lord, at page 1478, the order starts. And it is their petition. 1478, my lord, will find 13th July 2017. Before, my lord, the National Company Law Tribunal heard Mr. Sansad, J. Roy Shuni, advocate, and then, my lord, R. Banerjee and Aniruddha Sansad. Then, my lord, kindly come to straight away the last ordering portion at 1485. ওখানে বলা রয়েছে 1485, my lord, sees the heading TP number, which is, my lord, the transfer petition number 13 of 2016, and then, my lord, sees in brackets the original petition number is given, CP number 186 of 2013. Heard Mr. Sansaj, learned advocate Sansaj, represented by Sansaj, prayed for adjournment of grounds which are recorded in TS7. The grounds so taken are already considered found untenable for reasons more than one. Video order dated 13 July, TN number. In view of the above same grounds, proceeding 2 stands dismissed. So company petition also filed for asking for a right in their favor. That was also dismissed in 2017. This, my lord, again goes into, my lord, the question of prima facie case. And they, my lord, tried, my lord, for recalling. That was also, recalling application was also dismissed. Just for the records, my lord, can make a note of it. That is, my lord, at page 1487. Order dated 8 April 2022 and order dated 5th May 2022. which is my lord at pages 1487. Because after it was dismissed in 2017, they made a recalling application 2022. That's my lord at page 1487. And my lord, the 5th May 2022 order, my lord, the dismissal is my lord at 1489. Now, my lord, another court order I just want to show of my lord, this honorable court. While my lord, the matter was pending, my lord, before the during that period, my lord, when it was under abeyance, then again, my lord, they had tried. And my lord, they came to this, my lord, they made an application, my lord, before the civil judge. They failed there, they came up in revision. And my lord, kindly see, my lord, the order which was passed by this honorable court. My lord, on 26 July 2021, which is at my lord, page 1526. Of this honorable court, kindly see. Kindly see, my lord, at 1526, case number CRP 72 of 2020, Shormila Shetty versus B&A Limited and Somnath Chatterjee. Then, my lord, paragraph 2. Challenge in this petition under Article 2 to 7 of the Constitution of India as the order dated 7 March 2020 passed by the learned civil judge Jorhat in miscellaneous case number 222 of 2020 arising out of TS number 41 of 2012. Same suit, my lord. Then 3. Present petitioner, daughter of late Hemendra Prasad Borua and is a shareholder in a Respondent company. Company is enlisted Bombay Stock Exchange. Petitioner has 38% shares in the company. Then Hemendra Prasad Borua, father of the present petitioner, instituted suit. My lord, that is recorded. Then, my lord, kindly come to paragraph 10. Paragraph 10. I have given my anxious consideration to the submission of the learned counsel. It may be mentioned here that Somnath Chatterjee was named the sole executor of the will executed by late Hemendra Prasad Borua, who died on 31st July 2013, and therefore he has filed an application before the Honorable Calcutta High Court seeking probate, and it is still pending. Respondents pleaded that according to Section 211, according to Section 211 of the Indian Succession Act, Somnath Chatterjee being the sole executor of last will executed by Hemendra Prasad Borua is his legal representative for all purposes, and all properties of the deceased person vests in him. Referring to Section 213 of the Indian Succession Act, respondents in pleaded that when the probate would be given to the executor, then his right as executor legatee could be established in any court of law. Then 213 now knows has been deleted. It's with the last amendment, it's been 213 is now gone. Then kindly look at paragraph 14. 13. When Mr. Chatterjee at page 1531 filed an application in TS number 41 of 2012, he was not armed with probate because the application of probate was pending before Calcutta High Court. Therefore, in view of the law laid down in Section 211, 213, the learned court below passed a direction whereby the TS number 41 of 2012 was kept in abeyance. Order was challenged before this court, and this court, while disposing of CRP number 47, CRP number 97, upheld the order of the learned court below. Thereafter, petitioner filed another application before the learned court below, praying for passing an order that with the death of Hemendra Prasad Borua, and since his legal heirs did not file any application for impleading them in place of the deceased, the said TS number 41 of 2012 stood abated. The learned court below issued notice to the other side by filing the present revision petition. Petition has challenged the said order of the learned court below. This court has already agreed that till probate is granted to Somnath Chatterjee, TS 41 should be kept in abeyance. Therefore, this court has the opinion that the act of filing the petition before the learned court below seeking an order that TS number 41 of 2012 stood abated is contrary to the spirit of the order passed by this court in CRP 47 and CRP 97. I am constrained to hold that the petition miscellaneous 22 of 20 filed by the petitioner is a misleading one. Moreover, the court issued notice only for hearing of the answer. Basic tenor both sides deserves. And my lord, from there again, my lord, they went up to the Honorable Supreme Court. And my lord, at 1534, 18/11/2021, my lord, we were there. Then my lord, the special petition was dismissed. Let's see that the top, my lord, 1534, arising out of impugned final judgment and order dated 26 July 2021, which was what I read. So this was another attempt, my lord, while the suit was pending, was in abeyance. That, my lord, they tried to disturb, my lord, that position. And my lord, this court found that their application was a misleading one. And the special petition, my lord, was dismissed. My lord, just one more, my lord, factual aspect I just want to show. My lord, the rejoinder affidavit. Take it out. My lord, in 3982, my lord, the affidavit, my lord, I am told, my lord's officers, my lord, have.
Which affidavit?
My lord, our rejoinder affidavit in 3982, my lord, to deal with, my lord, the written objection of HDFC. Here, my lord, kindly come to page Malad 681, Malad, there's an application, there's an affidavit. I'll just give the page of Malad, that affidavit. Sorry, Malad, just give me. Malad, at page, Malad, it's 7, kindly come to 765, Malad. Kindly come to Malad, page 765 of that, Malad. It's an annexure there. Malad will find, Malad, that is an affidavit of Malad, the HDFC. In Malad, the Calcutta High Court, and Malad will recall, Malad, in the order of 28 January, Malad, there was a reference by this court, Malad, there was a reference to that affidavit, which is, Malad, this affidavit, 765. Kindly look at, Malad, 766, Malad will find I, Bishwanath De, son of such and such, aged about 47, by faith Hindu, occupation, son and such, working for gain at branch manager at HDFC Bank, UN Brahmachari branch, having its register office at 11 Dr. UN Brahmachari Street, Kolkata, do hereby solemnly. Then paragraph 1, I am the authorized signatory of defendant number 2. That is, Malad, in the Calcutta, before the Calcutta High Court. Defendant number 2. And here, Malad, there are 3. And as such, I am well acquainted. Then, Malad, straight away come to paragraph J, which is, Malad, at page 772. That taking, Malad, has that, Malad, 772 at the, that taking calculated an undue advantage of the fact that the aforesaid demat account could be operated from any branch of respondent number 2, Malad, which is HDFC, respondent number 1, which is, Malad, Shormila, with full knowledge of the subsisting ad interim restraining order dated 24th September 2025, passed by the Honorable Gauhati High Court, deliberately and malafide initiated a request for transmission of shares and intentionally approached the Sandoz branch, Mumbai, with the sole object of evading and frustrating the said judicial order, knowing that the said branch would be unaware thereof. Consequently, the transmission of shares was processed exclusively at the Sandoz branch, Mumbai, which at the relevant time had no knowledge or notice of the said restraining order, as responsible willfully suppressed and concealed the same and failed to disclose or produce any copy thereof, thereby committing suppression of material fact, playing fraud upon responsible to the bank, which is Mulad Bank, and this honorable court, and deliberately circumventing the binding effect of a subsisting judicial order. This is what the bank understood, and this is what the bank is saying. Then also, my lord, M, page 774.
M.
My lord, M for mother. The respondent number 2 states, page 774. Respondent 2, my lord, is the bank, states that the alleged transmission of shares occurred solely on account of incomplete and selective disclosure made by respondent 1, which is my lord Shormila, leading to an unintended inter-branch communication gap and not due to a willful act, negligence or malafide on the part of either the Sandoz branch or the home branch of HDFC Bank Limited. So what they did was, this depository account, the account we are talking about 301151 is maintained with UN Brahmachari Street branch, Calcutta. So they went and applied with the order of 15th September, saying, look, now the civil judge Jorhat has dismissed their application, no restraint order. Therefore, you transmit the shares. And they got that transmitted. That's how all this other things happened, and we filed this contempt proceeding as. And 66. In the same change. In the same affidavit, will find this argument which they make of transfer, transmission, and all that will be put to an end if looks at page 830, because I would presume that same submission will be made. It was rejected by the court and by the Honorable Supreme Court. Kindly look at page 830.
Yes.
This one annexure F. It will also have another number, page 66. It comes from that other affidavit, but it's 830 of my lord's brief. And sees from Bijay Shetty. Bijay Shetty is the husband of Shormila Shetty, who's really handling all this matter. And sees now subject. Date is 15th October 2025, which is after the order of 24th September. Very important letter, has that, page 8. Bijay Shetty, 15th October date, then writing to HDFC Bank, and sees the subject. Forward, certified copy order dated 15th September 2025. The Jorhat Civil Court. Transfer of, so he doesn't say transmission. He himself says transfer of my 86198 shares of B&A Limited from DPID 301151 account number such to DPID 300476 account number. Then says, dear Mr. Jaiswal, and written to the Sandoz branch here, there has been a huge delay in transferring my 86198 shares lying in my DPID 30014. This is not correct. It's not his really. At the branch of UN Brahmachari Street, Kolkata, which was held with my deceased father since 2008. I first sent you the order of a heavily contested matter concerning the shares held with my deceased father, dated, well, it says 15 September 2025, removing any restriction on the said shares from the Court of Civil Judge Senior Division, Joraj, on the 16th of September. These shares were to be transferred to my demat account. 300476, account number at HDFC Bank Limited, Sandoz House branch. I had provided with KYC documents for account with DPID 300476 nearly 2 weeks ago on September 25, if any updates were required. I then sent you a certified copy. Then kindly see, very important, my lord. I then sent you a certified copy of the same order dated 15 September 2025, removing any restriction on the said shares from the Court of Civil Judge Senior Division, Jorhat, on 29th September. Now, my lord, kindly see. And this is what the bank says the fraud he committed. Because this letter she committed, my lord. This letter is written on 15th October. His first request goes on 29th September and she suppresses 24th September. So, my lord, with great respect, my lord, why should the court, my lord, today trust or rely upon, my lord, such a, my lord, litigant? And then, my lord, he says, I have sent you a certified copy of this order dated 15th September, removing any restriction on the said shares from the court on 29th. I have already sent the order. I am unable to send it by email as it is 7 MB. It is divided into 6 emails less than 2 MB. I am now being told that because of the closure of trading window since 1st October, shares cannot be transferred. Block has nothing to do with transferring between my accounts. That only means promoters cannot trade in the shares till the next board meeting. These shares were stuck. Now see, my lord. Since 2013. And when I eventually do get a favorable order, and even after repeated follow-up, the shares are not being released to my account. Your bank is extremely hasty in blocking shares in my demat account, but no one will ever take accountability in releasing what is rightfully mine. I had the same experience with my demat account before. No one's inclined to answer. I'm getting satisfactory answer. And then, Mullah, the next page, Mullah, sees, Mullah makes a transmission form. He says transfer, then Mullah makes a transmission form. And without any further disclosure, wants Mullah the shares to be transferred. As if, Mullah, no litigation is pending, as if no orders are pending. As if, Mullah, it's a simple case of, Mullah, the father having died, it is going, Mullah, to the... Nothing else is disclosed. And the email is completely misleading. And this was what was commented on, Mullah, in the order of 28th January. That's why, Mullah, the learned, Mullah, this honorable court, Mullah, held that A, you could not have transferred in view of 24th September. B, you deliberately did not disclose 24th September, the order of this court, and you had wanted it to be transferred. And therefore, they directed that, Mullah, it to be restored back. And this question of, Mullah, transfer, transmission, in the letter, it doesn't find any place. It's, Mullah, we, the lawyers, Mullah, who have, Mullah, now tried to, Mullah, distinguish between transfer and transmission. Oh, actually, it's not a transfer, it's a transmission. Therefore, it will go to my single demat account, because this is, Mullah, the defense now taken. And I'm saying, Mullah, that defense is not available because your 24th September 2025 order says you cannot transfer. And the court interpreted cannot transfer as meaning it should be restored back. You took all this point to the Supreme Court. Honorable Supreme Court dismissed your special petition. So this transfer transmission story, yes, it would have made a difference. Perhaps, Mullah, if I was proceeding, which I still have the right, Mullah, to proceed in the Order 39 Rule 2A, to haul you up for contempt. To haul you up for disobedience of orders passed by this honorable court in not disclosing and acting in the mother's. So, my lord, this is, my lord, where, my lord, this stands. Now, kindly look at, my lord, in fact, my lord, it is also on record. I don't want to, my lord, go into it, my lord, in detail or my lord, but it is also on record, my lord. Record hai ache to, my lord, my lord, in connection with the mother's will, my lord, before the Calcutta High Court, the two wills, my lord, there are two proceedings pending, my lord, with regard to, in fact, my lord, a probate has been granted there. My lord, there they have transferred a property in violation of an order of court, and they are also facing contempt there in the Calcutta High Court. Same contempt. Yes. Now, my lord, kindly look at, my lord. No, first you give me that 71 Supreme Court. My lord, I'll. Just trying to, my lord, work out, my lord, the logistics and how much, my lord, we are going to travel, my lord.
I was trying to find out how long will he take.
Lord, I will finish, my lord. I maybe, my lord, another. For now, my lord, I'll. You.
Oh, no problem. I'm just trying to find out.
No, no,
I'm not saying that he should cut short his argument. I'm not saying that.
No, I will have to. I can't trouble my lord forever and forever. I also have, my lord. No, my lord, I'm only, my lord, concerned, my lord, about the, because I understand, my lord, I wanted to come back, or rather, my lord, if we could have finished it, my lord, next week, but I understand, my lord, is not, my lord, there next week. My lord, we can, if, my lord, it is possible, my lord, I can stay back, my lord, and try and, my lord, have this matter. If, my lord, subject to, of course, my lord's convenience tomorrow, my lord, if it is at all possible, then.
There's a miscellaneous day, we'll be having many matters. Possible, I think.
Not possible.
Apply will be there.
Then, my lord, we'll have to, my lord, well, I'll finish my, lord, submission. I'll finish my submission. I don't know whether my learned friend will be able to finish his submission or not.
Come over to Aizawl.
I'll be happy to do that when if learned friend accompanies us.
I have never been, my lord, so I would.
I've also never been.
My lord, don't, my lord, give this information, my lord, invitation, my lord, to outside lawyers, my lord, they'll all go and, my lord, land up there.
Weather-wise, my
It will take 3 days to go there.
weather-wise,
days,
my
my
learned friend will be finding it more convenient.
Huh? My lord, kindly look at, my lord, 71 Supreme Court in the same line, my lord, what I showed, my lord, in the Privy Council. My lord, this is now, my lord, showing us Supreme Court on this. Kindly take, my lord, paragraph. Paragraph, my lord, 21. It should start with the transfer. Or has that, my lord, the transfer with which? The transfer with which we are concerned in this case cannot be gift, because Dr. Pandit continued to be the owner of the amounts in question till his death. There is no presumption of advancement in this country. But yet, if there had been satisfactory evidence to show that the transfers in question are genuine, and further that Dr. Pandit intended that the amounts in question should go to the first defendant exclusively after his death. Here, my lord, first defendant was the son. We would have held that the advancement put forward had been satisfactorily proved and presumption rebutted. 22. It was for the first defendant to establish that there was a general intention on the part of Dr. Pandit to benefit him, and in pursuance of that intention, he transferred the deposits to the joint names of himself and the first defendant. If he had proved those facts, he would have made good his plea. See Young Sansaj. Then 23. In Guranditta versus Rimaditta, the judicial committee held that the deposit made by a Hindu of his money in a bank in the joint names of himself and his wife, and on the terms that it is payable to either of the survivor, does not, on his death, constitute a gift by him to his wife. There is a resulting trust in his favor in the absence of proof of a contrary intention, there being in India no presumption of an intended advancement in favor of a wife. Same view was expressed by Judicial Committee in Pandit Shambhu, which, my lord, I placed 45 Privy Council then. But the difficulty in this case is, firstly, there is no satisfactory proof of the alleged letter by Dr. Pandit to the Bank of Indore. Secondly, there is no evidence of the general intention on the part of Dr. Pandit to give those amount exclusively to the first defendant. In the letter said to have been sent by Dr. Pandit to the bank, all that is said is that he wanted to put the amount in the joint names of himself and the first defendant as he was seriously ill. There is nothing in that letter to show that he intended to make over the amount to the first defendant. As noticed earlier, Dr. Pandit was in his deathbed. Therefore, he might have thought it prudent to transfer the deposits to the joint name of himself and the first defendant to Malachi's facilitate collection. That being so, we are unable to uphold the plea of the first defendant regarding those deposits. Because here, Mullah, the first defendant was his son, we will find, and he was claiming that it was a gift to him. Sorry, 71. They are copy there, no? AIR, I've given it to AIR 1971, Supreme Court 1962. Paragraphs 21 to 24. There are several other judgments. I'm not only showing, I'm not multiplying the authorities. I'm only showing 45 Privy Council and AIR 71, Supreme Court 1962 on the proposition that putting it in joint name means nothing. Putting in first named holder is me and second named holder is someone else means nothing. If it's the shares of the first named holder, which is not an admitted position, it's only for collection. You do not get any right to the property. And the intention, Mulad, was also very clear. Now, Mulad, kindly look at, Mulad, one more, Mulad, the main case, Mulad, on which, Mulad, this nomination issue, Mulad, was considered, and in context of, Mulad, the NSDL rules, which is the stand taken by my learned friend's client. And, Mulad, also the trial court dismisses it, saying that, oh, NSDL rules are there. And which, in fact, Mulad, was told by us. Mulad, we only showed in the plaint, our apprehension was that if she gets it singly, she will transfer it in terms of NSDL rules. So I wanted to prevent the mischief from the NSDL rules. And that is turned against me and said, sorry, you don't have a prima facie case, application is dismissed. Mulad, this is, Mulad, 2024, 4 Supreme Court cases, 642, Shakti Yazdani and another versus Jayana and Jayanti Salgaonkar. Mulad of Justice, Mulad, Rishikesh Roy's judgment I saw, Mulad. Kindly come to paragraph 3, Mulad. 2, sorry. At page 649. Appellants and respondent 1 to 9 are the legal heirs and representative of an individual, Jayant Shivram Salgaonkar. Family patriarch executed a will on 26 June 2011, making provisions for the devolution of his estate upon the successors. Apart from the properties mentioned in the said will, testator at certain fixed deposits for the sum of 4 crore 14 lakh 73,000 in respect of which respondent numbers 2, 4 and appellant number 2 were made nominees. Additionally, there were certain mutual fund investments, MFs of the amount of rupees 3 crore 79 lakhs, in respect of which the appellants and Jaya Ganesh Nyas Trust, respondent 9 were made nominees. Testator Jayant Shivram Salgaonkar passed away on 20th. Then paragraph 3. On 29th April 2014, respondent number 1 filed suit number 503 of 2014 with the prayer for declaration inter alia that the properties of the testator may be administered under the court supervision and seeking absolute power to administer the same. He also prayed for permanent injunction restraining all other respondents appellants from disposing, transferring, alienating, assigning, and or creating any third-party interest in respect to the properties in Exhibit A. Then, my lord, paragraph 4. In their reply to the notice of motion in suit number 503, the appellants pleaded that they were the sole nominees to the MFs, mutual funds. Essence of their claim was that the appellants being nominees were absolutely vested with the securities on the testator's death. Appellant number 2 was additionally nominated and entitled to FDs of the testator in IDBI Bank. Also, the appellant's contention nomination made under Jayant Shivram Salgaonkar were made as per section 109A and 109B of the Companies Act and bylaws and such. Then, my lord, kindly come to paragraph 5. The discuss, my lord, in the Bombay High Court, my lord, will recall there was a decision, my lord, which said that they were actually the owners, the nominees were owners, which was considered, and then paragraph, my lord, 50 though. My lord, get to the paragraph. Or kindly come to sorry, my lord, kindly come to paragraph 45. Right? Yes, very important, my lord, paragraph 45. The appellant's case is grounded in the interpretation of term vest in section 109A of the Companies Act 1956 and my lord sees bylaws 9.11.1 under the Depositories Act 1996. And according to them, the use of the term vest indicates the intent to bestow ownership of the securities upon the nominees on the shareholder's death. To address the aforesaid argument, it apposite to note how the term vest or vesting has been defined by the courts from time to time. Yeah, my lord, instead of nominee here also, my lord, the second named holder is there. So they say, my lord, oh, depository participant, therefore it comes to us. So that's, my lord, what is being dealt with. Now, my lord, kindly come to paragraph paragraph 54 at page 665. As per bylaw 9.11.7 of the Depositories Act 1996, the non-obstante clause confers overriding effect to the nomination over and any other disposition stroke nomination for the purpose of dealing with the securities lying to the credit of deceased nominating person in any manner. Therefore, the purpose of invoking such a non-obstante clause is clearly delineated and limited to the extent of enabling the depository to deal with the securities. In the immediate aftermath of securities holder's death, the upshot of the above discussion is that the non-obstante clause in both section 109A3 of the Companies Act 1956 and bylaws 9.11.7 of Depository Act cannot be held to exclude the legal heirs from their rightful claim over the securities against the nominee. Then kindly see the heading, my lord. No third line of succession contemplated under the Companies Act. The appellants also contended that the nomination validly made under section 109A of the Companies Act and bylaws 9.11 of the Depository Act 1996 constitutes a statutory testament that overrides the testamentary intestate succession. Kindly see, this is statutory testament. It is worth noting that the argument of nomination as a statutory instrument in respect of
Testament.
sorry, I'm sorry, Mullah. It is worth noting that the আমার চোখটাই যাচ্ছে sorry, my eyes are not failing. That worth noting that the argument of nomination as a statutory testament in respect of instruments such as life insurance policies, government savings certificates, provident fund, etc., were considered and emphatically rejected by this court in multiple rulings. In Sharbati Devi, this court held that the nomination under section 39 of the Insurance Act 1938 does not contemplate a third line of succession styled as a statutory testament, and any amount paid to a nominee on the policyholder's death forms a part of the estate of the deceased policyholder and devolves upon his or her heirs as per testamentary or intestate succession. Further, in Ramchandra Talwar, while discussing the rights of a nominee of a deceased depositor, Section 45 ZA2 Banking Regulation, this court concluded that the right to receive the money lying in the depositor's account was to be conferred on the nominee, but the nominee would not become the owner of such deposit. The said deposit is a part of the deceased depositor's estate and is subject to the laws of succession that govern the depositor. Then appellants of 57, appellants have contended that nominations under section 109A of the Companies Act 1956 and bylaws 9.11 of the Depository Act 1996 suggest the intention of the shareholder to bequeath the share/securities absolutely to the nominee to the exclusion of any other persons, including legal representatives, and constitute a statutory testament. However, aforesaid argument is not acceptable for the following reasons. Companies Act 1956 does not contemplate a statutory testament that stands over and above the laws of succession. Companies Act 1956, as iterated above, is concerned with regulating affairs of corporates and not concerned with the laws of succession. The statutory testament by way of nomination is not subject to the same rigors as is applicable to the formation and validity of a will under the succession laws, for instance, Section 63 of the Indian Succession Act, wherein the rules for execution of a will are laid out. Therefore, the argument by the appellants of nomination as a statutory testament cannot be countenanced simply because the Companies Act 1956 does not deal with succession, nor does it override laws of succession. It is beyond the scope of the company's affairs to facilitate succession planning of the shareholder. In case of will, it is open to the administrator or executor under the Succession Act 1925, or in case of intestate succession, laws of succession determine the line of succession. Then, Mullah, conclusion. Consistent interpretation is given by courts on the question of nomination, that is upon the shareholders, that is upon the holder's death, the nominee would not get an absolute title to the subject matter of nomination, and those would apply to the Companies Act 1956 parameteria provision, the Companies Act 2013, and the Depositories Act 1996 as well. An individual dealing with estate planning or succession laws understands the nomination to take effect in a particular manner and expects the implications to be no different from devolution of securities per se. Therefore, an interpretation otherwise would inevitably lead to confusion and possibly complexities in the succession process. Something that ought to be eschewed. Then 61, Mullah, we can skip over. Then 62, very important. The vesting of securities in favor of nominee contemplated under section 109A of the Companies Act, parameteria 72 of the Companies Act 2013, and bylaw 9.11.1 of the Depositories Act 1996 is for a limited purpose, that is to ensure that there exists no confusion pertaining to legal formalities that are to be undertaken upon the death of the holder, and by extension to protect the subject matter of nomination from any protracted litigation until the legal representatives of the deceased holder are able to take appropriate steps. Now, Mullah, this is very important. Here, Mullah, the legal representative of the deceased holder, Mullah, is the executor. So he's already taken steps. So nominee now, Mullah, the second holder has no right. The object of introduction of nomination facilities via the Companies Act Amendment Act 1999 was only to provide an impetus to the investment climate and ease the cumbersome process of obtaining various letters of succession from different authorities upon the shareholder's death. Additionally, there is a complex layer of commercial considerations that are to be taken into account while dealing with the issue of nomination, pertaining to companies or until legal heirs are able to sufficiently establish their right of succession to the company. Therefore, offering a discharge to the entity once the nominee is in picture is quite distinct from granting ownership of securities to nominees instead of the legal heirs. Nomination process therefore does not override the succession laws. Simply said, there is no third mode of succession under the scheme of Companies Act 1956, Parametrial Provisions Companies Act 2013, and the Depositories Act 1996 aims or intends to provide. Then upon a careful perusal of the provision in the Companies Act, clear that does not deal with law of succession, therefore a departure from this settled position of law is not at all warranted. Implementation in the correct way, appeal is according to dismiss. This judgment, and kindly read with what I've already shown on the question of that, because even if you're a joint holder, second named holder, it doesn't go to you. Ownership doesn't go to you. It is akin to nominee. And this judgment is relevant and very important to also show that law of succession overrides provisions of the Companies Act and Depositories Act. That is the principle. Law of succession overrides the provisions of Companies Act and the Depositories Act, which is where, with great respect, the learned civil judge went completely wrong. Learned civil judge has ignored and completely forgotten what was the purpose of the suit itself. And it was to preserve and protect ownership in the plaintiff, which is Hemendra Prasad Borua, who is now being represented by the executor. If we allow someone else to take away the shares, it will be usurpation of the rights, ownership rights of the plaintiff. And who had obtained an order of status quo, which means the shares would have existed and continued in the original dematerialized original account 3001151. And the suit having been filed, and sees all these cases, which the other cases which I showed, 45 Privy Council and 71 Supreme Court, they all happened when the person had died. But here I'm on a much better footing. The will is there, and not only that, during his lifetime, he has instituted a suit. But I think that we'll have to perhaps come back, because I don't think both sides will be able to finish. So if any date after comes back, if
Agree on a date.
28. We can do it immediately after
Next week, your lordship is not there. Here after also we can do it.
After Bihu Karo. We'll also have that Poila Boishak and all that. Have similar periods of
different name.
Huh? Motion bhi karenge. Kab just kab
28 देखो.
हाँ 28 को 28 को The 23rd April, subject to convenience and approval, it's a Thursday. But if the matter is heard in part,
All right. Heard in part. Is the matter again on?
the interim order can continue. It's been continuing.
Third. 23rd.
23rd April, my lord. I think that's going to be subject to my lord's convenience.
These are your copies
Sorry, my lord. Yes, ma'am.
that you have submitted. So we have to keep it since we have marked these copies.
Yes. Yes, ma'am. Yes.